And then
Are we good to go?
we are good to go, Chairperson. Thank you for your patience.
All right, welcome everybody. I'll call to order this meeting of the Village of Germantown Board of Zoning Appeals. This meeting has been given public notice in accordance with section 19.83 and 19.84 of the Wisconsin statutes in such form that it will apprise the general public and news media of the subject matter that is intended for consideration and action. Madam Clerk, please call the roll.
Board Member Tim Edwards.
Here.
Board Member Jeffrey Knopp.
Here.
Board Member Christine Huber. Here. And Chairperson Barry White.
Here.
Also present is Village Clerk Donna Ott, and our Community Director is Jeffrey Retzloff, also present, and our Village Planner Jordan Yankee present, also our Village Attorney Brian Sadak.
All right, thank you. Normally, our first order of business is approval of the minutes. I'm informed that we don't have a copy of the minutes from our last meeting, which was May 14, 2024, and I hadn't seen any. So we're going to defer consideration of those minutes until the next meeting, or assuming we have them. And we'll move on to our first hearing. For the first hearing, the purpose of this hearing will be to hear any and all parties, their attorneys or agents, for or against a variance appeal filed by Ronald Peterson, property owner, for a variance from section 17.16 sub 3 of the village's zoning code to reduce the minimum side yard building setback from 20 feet to 12 feet, a variance of 8 feet, for purposes of enlarging an attached garage on the property located at West 132, North 11267 Forest Drive, Germantown, Wisconsin. Mr. Peterson? Nice to see you. So I know we did this once before, and what I always say to everybody is it's important, well, let me back up. It's important for our record and for the board to even though we may have a recollection of what we talked about last time, it's important for us to go through the process again and make a determination today based on what happens at today's hearing. And so, like I would have told you before, that typically what I do is give the person who is seeking the variance the opportunity to go first if he would like. But what we usually find works well is for our village planner to explain what the code is and why it's there, and then have you ask or explain to us what you're asking, how you're asking to deviate. Does that make sense? Would you like to go first, or would you like? All right. Before you begin, let me swear you in. Please raise your right hand, unless you do it. I think I do it.
I do it.
Do you? All right.
Correct.
I always used to do it. Either way. Huh?
I'm happy for you to do it if you want to go off the script and do it.
Well, I just do it from memory, but yeah, no, that's what I say. But as long as you have the authority to do it, I just as soon you do it.
Yes, perfect. Mr.
Sure.
Bob, trustee.
Uh-huh. I have no, does anyone have any objection to that? Is there?
And if your decision is to do that, then we would need a motion to change the order.
Right.
of the
Oh,
agenda
good catch.
as well, okay? And I'm only going to swear on people that are going to give testimony.
Of course. Yeah, okay. Well, let's do that. How about a recess for what, 10, 15 minutes, whatever you need. All right, well then I'll make a motion that we recess for 10 minutes, whatever it takes. All in favor? Aye.
Aye.
Opposed? All right, we're in recess. All right, I'll call this meeting back to order. And as we said, the first hearing relates to the variance petition filed by Mr. Peterson. Looks like he will be appearing by an agent.
By an agent.
Now,
Yes.
are you still thinking that do you want to go first or would you like,
I would like to go first
Okay.
at this point, and then we will allow the department heads to discuss as needed.
okay. So our clerk will swear you in.
Hi.
Hi,
Please raise your right hand and state your name.
name is David Baum.
Do you solemnly swear to tell that your testimony that you shall give in this matter shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you. Is anyone else speaking on behalf of the Petersons beside from yourself, Trustee Baum?
I do not think anybody else will be talking.
I will just swear in you at this time, and then we will proceed with the swearing in when our staff goes ahead.
Very good. So I have been asked by the applicant to come forward and talk in his behalf. The last time this item came forward, the applicant was not aware of how this happens, the process of how this happens. He believes he didn't get a fair understanding of the situation. The situation has actually deteriorated since that time. The applicant has a health issue, which is compromising his physical abilities to get into his house. He would like to put a handicap ramp into his house, get more space around his vehicles so he can get in and out of the vehicles with his scooters and walkers, which requires the garage to be enlarged. When I initially talked to the applicant about this, I said, let's expand the garage to the front or to the back to elongate it so we're not going towards the property line. While I thought that was a solution to the problem, the front to back dimension is not the issue. It is the side to side dimension that is the issue. We cannot put a handicap ramp, a car with additional spacing, within the confines of the current garage. They would like to expand the sidewall, the 8 feet, which is the request, so that they have more room side to side to get into the house. That is the issue that we are looking to have addressed by you today. I am happy to discuss and answer any questions that you may have regarding the consideration of this. When I was out at the site in this neighborhood, there are 1 acre sites and there are larger sites. The property directly to the north of the resident is a little bit larger than the 1 acre site. There is ample dimension between houses. I felt that it was acceptable to expand and encroach upon that property line, the 8 feet. There is a good 40 to 50 feet to the next house. That is why I am here supporting that we can expand this garage to the north to allow the additional dimension, to allow this applicant to stay in their home, to live an independent lifestyle if they have the assistance of handicap ramps and space around their vehicle. If there are any questions, happy to answer them.
Yeah, I have one to start. That as I understand our authority to grant variances, and the other members of the board may have a different understanding, but my understanding is that our ability to grant a variance turns on what's unique about the property, not a particular property owner's individual needs. And I'm terribly sympathetic to Mr. Peterson and right and
Mhm.
yeah, would am looking for a way to help him out. What I would like you to speak to is anything unique about this property, not Mr. Peterson's condition, but the because remember too, if we grant the variance, it runs with the property forever.
Sure.
And which may or may not, depending on how long Mr. Peterson lives there. So what I'm looking for is there anything unique that you can point out to me about this particular piece of land that requires the variance, the encroachment into the setback in order for Mr. Peterson to be able to use to enjoy the rights that other property owners get to enjoy?
I'm sorry, Trustee Baum. Before we do that, can I just jump in on that kind of issue ahead of time? Because while I think that your understanding of typical variance law is correct, it gets complicated a little bit when you start talking about disabilities.
That was gonna be another question that I had.
So we have the Americans with Disabilities Act,
Right.
there's, the Rehabilitation Act, there's a number of similar type acts at the federal level that protect folks that otherwise have some level of disability. What the case law all surrounding those types of circumstances is, I'm kicking things all over the place here. The case law on those things effectively says that while you generally don't get a variance based on a purely personal type situation, that it's got to relate to the property, where you are dealing with a disability, you can potentially. And there's a case out of 2001. It's Wisconsin Correctional Service versus the City of Milwaukee that really talks a lot about kind of how you analyze that process. And what that case says is that, and it's not so much a how do we grant this decision, which is typically looked at by the zoning standards that we have. But instead it couches it in the frame of like, if we were going to, as a body, deny this request, that would potentially create a cause of action. And in order to get relief under the ADA, to do that, it says that there's a couple standards that apply. So what the case says is, number one, you obviously have to have a qualified individual with a disability. That one's the toughest one to do because generally as the government, you can't then say, well, what's your disability? Tell me about it. And we're going to vet it, because that in and of itself is discriminatory. So generally, if somebody comes forward and asserts a disability, you generally take them at their word for it, unless there's some basis that would, that is known publicly that might change that. So I think we have that probably here. The second thing is that effectively under the ADA for the lawyer in the room, but for those of you who maybe don't know, what the ADA really contemplates is giving some level of reasonable accommodation to an individual to assist them in their daily lives, in short. And so what the second piece is that the case says is that reasonable accommodation can't create a fundamental change in the process and the zoning code and those types of things, which even this case kind of suggests that it was pretty much ignored in that case, and the court even says it probably is for a reason, because it's hard to see how merely granting a variance from a body who otherwise grants variances is working some sort of fundamental change that's involved here. So that one generally is not an issue. The third factor is that the relief has to be reasonable. Now, we don't, when we think reasonable, we have the reasonable that us normal people think of. The federal government confuses that by giving us a different definition of reasonable. And what the reasonable in that case is that the accommodation doesn't impose an undue financial or administrative burden on the particular individual. And if it does that, then it's not reasonable. If it doesn't, then it's reasonable. However, the court says is as we analyze that, what the courts and ultimately this body is free to do is that you effectively balance the extent of the accommodation, the extent to which the accommodation undermines the legitimate purposes and effects of the zoning regulation with the benefit provided. So, in my mind, when I read that, I'm kind of kicked back into the, okay, now we're kind of back into the normal zoning realm of, we're going to look at, what's the hardships? Are there alternatives? All of those kind of factors that we otherwise look at to try to figure out, are we in some way truly impacting the purposes and effects of the ordinance? And if so, we got to balance that with the benefit of what's there. The final thing that the court says is required is that the relief has to be necessary. And again, there's necessary in normal people world, and then there's necessary under the federal world. And necessary in this case means that it has to be, the relief has to be capable of providing direct amelioration of a problem faced by a qualified individual with a disability. And what the court talks about in this particular case is that this is really where you really focus on the alternatives. So like in this particular case, there was a number of different properties that this Wisconsin Correctional Service had looked at as possible locations for the site. The court said one of the things that you certainly can consider is that, what other sites are still available, and do they have benefits that are better than the current site or not? And, might this other site work better for various purposes? So, again, back into that kind of normal zoning concept of, are there alternatives? And the key takeaway, I guess, from all of this that I take from the case law is that you still analyze it a lot like a traditional variance, in that you're looking at, what type of hardships are there? Are there alternatives? What type of relief can be provided? How can are there different ways that you can provide that relief, that kind of stuff. But when you're doing that, you always have to be mindful of that. You have to balance it with what are the benefits and the costs associated with the individual, that individual with that disability. So there's not a good answer, like a bright line, yes, no, kind of a thing. It's very much fact determinative, but that's kind of the way the courts analyze whether or not you denying a request for a variance would be actionable potentially under the ADA.
That's helpful. Does anybody have any questions for the village attorney, Brian Sadek? All right, Mr. Baum, to the extent playing off of what Attorney Sadek said, is it your understanding that Mr. Peterson does have a disability?
Mr. Peterson does have a disability.
All right. Do you have, does this proposed variance in the construction of a bigger garage, that won't pose any undue hardship or administrative burden on Mr. Peterson because he's asking for it, right?
We looked at other alternatives to expand this garage, and they would not resolve the situation. Expansion to the north is the only solution to his handicap access of his house.
Okay. Any questions? Go ahead.
So could you help expand a bit upon how this expansion will help with handicap access? Because the last time we talked about this, I think it was all about wanting to have the yard equipment and the snow blower in the garage as opposed to in another shed that I believe was at the back of the property. And even when I look at the document that has been submitted, it looks pretty much exactly the same as what we saw last time, except now it's 8 feet instead of 10 feet, with a box for a yard utility vehicle and one for tractor with blower.
Yes. As I got brought into this, that is what was presented to me as well. And that's why I went out and started looking at expansion front and back, because if you want to use this equipment and have easier access to this equipment, okay, I can do it here and here. I don't need this. I told the applicant, no, you don't need that. We can go this way or that way. When it comes down to having his cars in the garage, putting a handicap ramp into the garage. There's not enough physical room north to south to fit a handicap ramp, cars with handicap clearance on either side of the car. If he's driving, if he's a passenger, there needs to be more room in the garage for all of that, north to south, not east to west.
So it really has nothing to do with yard equipment. He's not gonna put yard equipment over there. He's
The
gonna
yard
have his
equipment-
cars over further, so there's room for
The
a,
yard equipment became irrelevant
right.
when I started looking at this, when I started talking to them. It's not about the yard equipment. It's about his ability to get in and out of his vehicles and get into the house.
So there'll be a ramp installed, you
Yes.
know, that is more or less a permanent fixture,
Mhm.
obviously coming out a bit, and then the cars have to be
Right.
further over.
Right? This is a purely a handicap. When the applicant came forward, he was not understanding what your requirements were. He wanted to, I'm a proud man. I want to be independent. I want to get on my tractor. That's really not the issue.
So is
issue-
there, I'm sorry, is there like a plan, you know, some blueprints or diagram of how this is going to be laid out? Somebody who's bid on putting in this ramp?
We do not have that today, but if you would like it as part of your criteria, we'll be glad to bring a plan forward as to how this would be worked out.
Just trying to understand. you
If we
know,
make it a condition of approval, we'll be glad to bring a plan forward. They have consulted with people. I am an architect myself. I've looked at the dimensions. If we expand this garage by 8 feet, we can get everything in there.
All right, thank you.
Anything else for Mr. Baum right now?
I do have a couple questions from staff's perspective of the applicant or Mr. Baum, but I don't want to,
this-
don't want to interrupt any of your thoughts.
Right.
So
Anyone? Okay. Are your questions for Mr. Baum?
correct.
And Mr. Yankee, are you going to have anything that you want to add?
From a presentation standpoint, if you want me to go through, you guys kind of summed it up and sort of trustee Baum, so unless you want me to, I don't have anything at the moment.
Okay, well, let's see after we finish and hear what Mr. Sadek has to say. We'll see if it'd be helpful or if there's more you want to tell us. Go ahead, Mr. Sadek.
So what other alternatives did you contemplate?
So on the illustration on the screen, looking at the garage, which is the right side of the plan, I advised the applicant to build out the back. If your issue is your lawnmower, you can easily expand out the back, which is what was presented to your organization. It's my lawnmower. As I got involved with the family, it's not the lawnmower. He cannot get into his cars and get into the house in this garage. The northern expansion, which is further to the right on the screen, which is where the asphalt driveway currently goes beyond the garage on the north side there, is where he would like to expand the garage another 8 feet, which encroaches on the 20 feet down to 12 feet. It is that area that he would like to expand the garage out so he can get his cars in the garage. We talked about coming forward. That doesn't work either. It's the north-south dimension that we need to resolve for ADA accessibility. Ramp, if you look at a parking lot, when you put a car in a handicap spot, there's an 8-foot clear space next to the car. In a typical garage, you have a 16-foot door, which is what you see there. That space is too narrow for 2 cars and a handicap clearance. Trying to get that handicap spot inside the garage. That's why we need to widen the garage.
Did you contemplate putting the ramp to the front door instead of the door in the garage?
Yes,
And
We
does that
did.
work?
it doesn't, it is a alternative solution. However, I cannot get out of the car in the garage. I don't have the handicap clear space next to the car. So I can no longer pull my car into the garage and park. and get out of my car because I do not have the handicap clearance.
How many cars does he have?
2,
Does he need to park both cars in the garage?
yes.
Why?
We all park 2 cars in the garage. If I park them side by side,
I have a neighbor that doesn't. He's got a 2-car garage. He parks both cars outside.
the applicant wants both cars in the garage for safety and security.
Yeah.
And
Uh,
if I'm getting out of my car in the snow, I am hampered by the elements of Wisconsin winters. Today, would you like to get out of your car out on the driveway?
What about turning the garage, adding on and turning the face of the garage so that it was a side entry? Seems like you would have unlimited room then in that
I-
direction.
I think that goes to the undue economic impact to tear off this garage and build a new garage 90 degrees is economically infeasible.
No further questions.
All right, Mr. Yankee, what do you have anything that, that you're dying to tell us?
No, I figured I'd just add in, oh, sorry.
Oh, yep, thank you.
You're welcome. Thank you. Raise your right hand, thank you, and state your name aloud.
Jordan Yankee.
Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, Village Planner Yankee.
I think you probably addressed this already, but just for the record and to ask out loud, I did talk to the property owner about a potential detached accessory structure that could be located behind the current garage with a driveway extending there and potentially certain covered walkway and or something to get his equipment in there. Do you mind addressing that and maybe the accessibility discussion now that's come forward more recently
Sure.
addresses
The-
that, but
The issue is not the equipment, the lawnmowers. It's not that. That is what he brought forward. Proud man, I don't want to admit my issues. The issue is he cannot have his cars in the garage and get in and out of his cars, get into the house. I need a handicap ramp. I need an open space next to a car. I need the car. I have a second car. I want 2 cars in the garage. I need to expand the garage. This house was built 40 years ago, 50 years ago? How long ago was the car built? The house built? House was built in 1965. In 1965, none of us contemplated where our health would be going forward. They built it, unfortunately, right at the setback to the north. Today, we are now hampered by physical disabilities, ADA guidelines, and we would still like to maintain our independence and have access to our house so that we can live an independent lifestyle.
Go ahead, please.
So is there any like particular unique reason why he would need to have 2 vehicles? Many people have only 1 vehicle, and it sounds like he could adequately park 1 vehicle inside the garage, the primary vehicle. And it's convenient that there does appear to be an asphalt pad of some sort off to the side where the other vehicle could be stored.
My response to that would be, I have pulled my car into the garage where I wanted to be. I got taken to a medical facility for whatever treatment I have, and my wife came and picked me up. My wife wants to pull me in the garage on a snowy day like today, and there is no room for this person to get in and out of that second car. Somebody has to get out in the snow and rain and sleet, move cars around. The convenience of simply accessing my house this is what is the best solution for the applicant.
Anyone have any more questions for anybody? Because we always ask, is there anyone here that's here to speak in favor of the requested variance? Anyone here to speak? Oh, yeah, you're welcome to. Oh, please, go, come up. And then we got to swear you in and you got to tell us your name and address.
My name is, first I get to be
Yep.
sworn in.
I'm going to ask you to raise your right hand and state your name aloud for the record.
Joy Pills.
I'm going to ask you to pull that microphone forward to you and you're going to speak in that, please.
Joy Pills.
Do you solemnly swear that the testimony that you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, and then I'm going to write down your name with your correct spelling.
Okay.
How do you spell your first name?
Joy
J-O-Y. Spell your last name?
Pilz.
P-I-L-Z as in zebra.
Yes. Yes.
Okay, and your address?
873 Ravine Ridge Drive,
It's Ravine, R-E-V-E-N-E,
Ravine,
Ravine Drive, and is that in?
Ridge Drive.
Ridge Drive?
Yes.
Okay, so
And-
Ravine Ridge Drive, and that is what zip
Colgate.
code? Colgate?
53017? Yes.
Thank you. You may proceed with your testimony.
Okay. I guess I just, in response to your question regarding the number of cars, I have to say that, yes, my mother needs a car. My father has a car. They attend different activities. And my mother is 88 years old. Having her park outside in winter conditions is not, I don't think, feasible. We want to keep her healthy as well. And even the thing about putting the ramp to the front door, that doesn't solve the issue of keeping my father safe from having to go out in the elements. If it snows out, how's he gonna, he's got to wait till the snow gets removed then to be able to either come into the house or leave the house. So having it all within a garage, I think is the safest thing for both my parents.
Thank you. For anyone intending to speak in opposition to the variance? Anyone who wants to be heard, not either for or against, but just to be heard on this appeal? Okay. All right. Anybody else have anything else they want to talk about before we close the hearing and make a motion? All right, then we'll declare the hearing closed. I'll move that we grant the variance. Is there a second?
We're not going to go through that.
Yeah, somebody's got to second it first though, because I moved, and then we get to do it. So somebody, but if nobody seconds it, it's denied because the motion didn't get a second.
I'll second the motion.
All right. Motion,
Jeff Knope.
Thank you.
the motion having been made and seconded, we can begin our deliberations. I think it is worthwhile to talk about the four factors that Brian Sadak alerted us to. And the fourth factor kind of takes us through our normal findings of fact. And so at least with respect to the first factor, Attorney Sadak alerted us to, whether this is a qualified individual with a disability. I think what our lawyer counseled us was that we have to take the applicant at his word. So I think we've got that one, right? Okay. Secondly, whether this reasonable accommodation that's required under the American with Disabilities Act can't be a fundamental change to the zoning code. Seems like a requested 8-foot variance. We've granted bigger things than that. So it doesn't strike me that one could claim that that was a fundamental change to the Village of Germantown zoning code.
I agree with that.
Chairman White, I apologize for interrupting. One of the things that Mr. Peterson had asked me was that if you guys could talk face forward,
sure.
because he is very hard of hearing. So if we can talk and, more
Sure.
that direction with your microphones on, please.
All right, so Mr. Peterson, we're working our way through the 4 factors that Brian Sadak told us about, and so far, we think factors 1 and 2 support your request for a variance. Request number 3 is whether, or factor number 3 is whether the requested relief would have undue financial or administrative burden on the applicant. Since he's asking for it, I would assume that it is not. Everybody agree with that? And Mr. Baum testified that it's not. I mean, if he wants to build the garage, he can obviously afford the garage. I mean, it's not for us to say it's too expensive for him. We don't even know how much it'd cost.
Agree with that. I would agree with that.
Yeah. All right, so then our 4th consideration, according to our lawyer, is that the relief must be necessary. And as I understand, what we've been told is that the word necessary requires us to sort of consider the other factors that typically apply to a requested variance. And so the first one is whether or not the variance will be contrary to the public interest or in accord with the spirit of the zoning code. Anyone have any? I have thoughts, but I'm happy to hear anybody else's.
I don't see it being contrary to the public interest.
That's my thinking too, especially since these are big lots and so the setback isn't going to affect the adjoining neighbor. I don't see that as contrary to the public interest or the zoning code.
I would just say that while the initial issue that Mr. Peterson has raised concerning the lawn care and winterizing, snow removal equipment and such has been downplayed in this hearing, I still have a feeling that some of that is still a factor, but that factor is still relevant. So whether some of the space that might be created by expanding the garage to the north would be primarily for more room to get in and out of a vehicle, there might be some storage there as well that would make maintenance of the yard still possible for Mr. Peterson. And I still think that that is a valid factor to consider.
On item number, we're still on number 1, I think, right? That whether it will be contrary to the public interest or in accord with the spirit. I think your point maybe goes more to 2, but I see what you're saying. I don't discount what you're saying. I think that I still think this particular variance is not contrary to public interest or the spirit of the zoning code.
And my apologies, I was following along the 1, 2, 3, and 4 points that were pointed out by, I believe, was it the village attorney?
Oh, yeah, okay.
Which has to do with reasonableness of the request.
Right, okay, yep.
And I too,
Yeah.
Chairman, if I may, when we get to the findings and facts and decisions, if you could let me know then when we're doing the variance portion, question 1, 2, 3, 4, so that I can follow along as well, because I was under the same impression.
Oh, okay. My understanding from the village attorney was that his 4th factor, which is whether the accommodation is necessary, requires us to sort of weigh all the factors that we usually look at for a variance, at other options, whether or not it's really necessary, how necessary it is, those kind of things. And so in considering factor number 4 under this ADA rule, I went immediately into our findings of fact. And so that's what I was doing. That's what I understood him to have said, that the question of reasonable accommodation, whether the accommodation is necessary, are kind of the same considerations. That's what I understood him to say. Does anybody have a different view on what we were advised by our lawyer?
I think that makes sense. Eventually, we do have to come to the to the questions concerning a variance. and-
Right.
Yes.
And but it is slightly different because it's not necessarily exclusively property focused now, because we do have an applicant with a disability.
Correct. And maybe you said this, but also stated that those findings of fact are weighed against the cost to the applicant, like the cost of, because of the, the disability, right?
Right.
Weighing the body of facts against that.
So if we do move on now to the normal 4-part conclusions of law that, or 5-part conclusions of law that we always do. The first one is whether or not the variance will be contrary to the public interest and whether it will be in accord with the spirit of the zoning code. That was the one that I kind of jumped the gun, but I spoke to that one, and I think that I continue to think that it is not contrary to public interest, and I think it's in the spirit of the zoning code. Anyone disagree?
I agree.
I agree.
Okay.
Agreed.
So then if we move to our normal number 2, which is whether there are exceptional, extraordinary, unusual conditions or circumstances that apply specifically to this lot or parcel that don't apply generally. Here, it's my understanding at least that we're not looking exclusively at the extraordinary or unusual conditions of the land. We are also taking into account the situation of the applicant. And in that case, I mean, the only testimony we really have is that, and I understand exactly what you're saying, that he's still probably going to put stuff in there. But nevertheless, it sounds to me like he otherwise still needs it. And I would be, on the record we have before us, I think it sounds like he needs it.
We haven't seen, at least on the screens here in the boardroom, we haven't seen the plat map of Mr. Peterson's property. Now it is coming up. These lots, as Mr. Baum said and described, and I have seen for myself, are very large properties. Some were described as an acre or more. There's also a bit of a tree line to the north of Mr. Peterson's house that blocks, I would imagine, some degree of the view of his garage to the neighbor to the north. I've
Mhm.
noticed that myself.
Yeah, there is an aerial. There we go.
So considering the two factors, the factor of the disability and the nature of the lot, I guess you could call it the uniqueness of the lot because it is a bit larger than most in the village. I would agree that there are exceptional or extraordinary or unusual conditions that apply here.
So I guess, I think that last time around, I think that it kind of failed this criteria. Because quite honestly, in my mind, I don't see anything unusual about the lot itself. Yeah, it's a larger lot, but for the zoning classification that it's in, it's typical. It's your basic RS3 or whatever it happens to be. It's a pretty standard lot for that zoning category. But, now that we get into the intended use, I guess, is where there could be a different conclusion than we reached last time, when last time it seemed to be, mainly about wanting to have your snow blower closer, to the front door versus having to go out to a shed. So, based on that, with that intended use, I think I could get there to say that there are exceptional circumstances that apply to the intended use, maybe not the parcel and the structure, but the intended use.
I think
I
that's-
think I could get there where, maybe I thought it was a little questionable last time around.
Yeah, no, I think that's a good point. Did you get enough?
can just, I'm happy with putting in the minutes as long as we can all, if you want to pose the question, do we all agree that there are exceptional?
Do we all agree that, that there are exceptional or unusual conditions that apply to the intended use?
Yes.
And in our balancing of the ADA versus the zoning code, where we figure that this factor weighs in favor of the variance, right?
Yes.
Okay. Number 3, the variance is or is not necessary for the preservation and enjoyment of substantial property rights possessed by others. Again, I think this is tempered with, it's not, the disability in the American with Disabilities Act, and the requirement that he's entitled to reasonable accommodation. So just on the basis of that, I would say that from what Mr. Baum has told us, that expanding the garage is necessary for him to be able to use his property the way that other people get to use their property. And I get the points about, maybe you could park outside, but I'm kind of persuaded by if his wife takes him to an appointment or something, that she's got to be able to park in the garage too. I thought those were good questions, but I thought they were sufficiently answered to my satisfaction anyway.
I agree.
I agree.
Agree.
Okay, so we're all in agreement that the variance is necessary for the preservation and enjoyment of substantial property rights, given the disability. All right. Number 4, the variance will or will not create substantial detriment to the adjacent property and will or will not be contrary to the public safety or interest. I don't see any effect on the adjacent property.
I would further make the argument that if Mr. Peterson was not so diligent in maintaining his property, that the deterioration of the property would be more detrimental to the adjacent properties.
I think that's a very good point. So we're all in agreement that there is no substantial detriment to adjacent property, and it is not contrary to public safety or interest.
Yes.
Agreed.
Okay. And then number 5 gets us to whether a literal enforcement of the terms of the zoning code would or would not result in practical difficulty or in unnecessary hardship. And that's kind of Mr. Baum's whole argument, that it would create practical difficulty and unnecessary hardship. And I didn't hear anything to the contrary, so I'm persuaded. Okay, so we're unanimous on that one as well. Therefore, having deliberated it, I can ask Madam Clerk to call the vote. So the motion is to grant the variance.
Include in your motion, please, that we are the variance for 8 feet.
Oh, yeah, okay, so the motion is to grant the variance of a reduction of
From 20 feet to 12 feet.
from 20 feet to 12, right, yes. So the motion is to grant the variance allowing, reducing the minimum side yard building setback from 20 feet to 12 feet, a variance of 8 feet. And so that's the motion as it presently stands. Do you feel compelled to add a condition that we see the plans? You had mentioned that at one point. It seems cumbersome.
Yeah, I think that would just
Yeah.
be administrative
Yeah.
burden.
Okay, then the motion is, as stated, that we grant the variance to reduce the minimum side yard building setback from 20 feet to 12 feet, a variance of 8 feet. All right,
And you're making that motion?
I am making that motion, yes.
We have a motion on the table. Do we have a second?
I thought we did. I thought we did this already.
We did the second.
Yeah, we're just voting. Oh, yeah.
I will second it if we need a second.
Sorry,
motion.
I was still, I thought we were still figuring out how we were going to word the motion.
Oh, maybe.
All right, and the second was by Board Member Edward, or
Jeff Knopp.
Jeff Knopp, okay. And then we want to do a roll call vote.
Yep.
Okay, Board Member Edwards,
Yes.
Board Member Knopp.
Aye.
Board Member Huber. Chairperson White.
Aye.
you.
All right, Mr. Peterson, your variance was granted this time. So, all right, well, thank you, Mr. Baum. We appreciate it. Does anybody need a break? Does anybody who's going to be participating in the next hearing need a break before we start? Anyone on the board? Okay. That concludes hearing number 1. We will move on to hearing number 2. The purpose of this hearing will be to hear any and all parties, their attorneys or agents, for or against an appeal of an administrative determination of the Plan Commission filed by County Line LLC property owner. The determination of the Plan Commission was made on August 12, 2024, requiring removal of an existing non-conforming pylon sign from property at the corner of County Line Road at Appleton Avenue as part of approving wall signs for a proposed Chase Bank on the subject property. All right. It looks like we have Brian Randall on behalf of the appellant or the applicant. I guess you're an appellant. We mostly do variances.
Well, got to turn the page in the chapter.
Yep. I guess it would be, yeah.
So red is off, so this is on.
Red is off. Nothing is on. And Mr. Randall, when I say we usually do variances, I've been on this board for maybe 10 or 12 years, and we have done one that was not a variance. And so, and I don't even remember who all was here for that. And so go slow. Because this is, and we'll, Mr. Sadak will help as well, but just recognize that this is not second nature to any of us.
Understood.
Okay.
I think what I'm going to do, because I know our Community Development Director, Jeffrey Retzloff, is going to want to speak and provide some information. So I will do both of you at this time. We're starting with you, Brian, if that's okay.
Sure. Are you going to offer actual testimony, or are you just making argument? I mean, I argue motions all the time. Nobody ever swears me in. Now, Mr. Retzloff, I think, is going to give actual evidence. Are you going to, if you're going to give evidence?
I'm a member of the bar as well as state bar, so sometimes in municipal law, that's automatically qualified as being sworn in, but I don't mind swearing in.
Okay, let's do that and make it easy.
And that way,
Okay.
whatever I say, you can put in whatever bucket it applies to.
Thank you. That makes it easy.
Thank you for raising your right hand. Please state your name and raise your right hand, which you've done, but state your name for the record, and then I'm going to ask you to spell it.
Brian Randall, BRIAN, RANDALL.
And I do have the address on behalf of who you're representing, so I will just use that for later reference. Thank you for that. We will now go to the swearing in of our Community Development Director, Jeffrey Retzloff. Please state your name aloud, spell it, and then we will go. Let me come back to you. I apologize. I didn't do the swearing. Do you solemnly swear that the testimony that you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Jeffrey Retzloff, Retzlaff.
Thank you. Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
If you're swearing at him, you might as well swear at me too. Or I mean, swear at me too.
And can you share the microphone? State your- Out loud
Sure. Brian Sadak, SAJDAK, Village Attorney.
and raise your right hand. Thank you. Do you solemnly swear that the testimony that you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
All right. I would assume as appellant, Mr. Randall, we'll hear from you.
Thank you. I'm happy to do so. And while I distributed a packet, as I mentioned, I don't necessarily want to talk about it all, and I'm frankly, I'm going to go in reverse order. But my name is Brian Randall, as I've just testified to. I'm an attorney with Amundsen Davis, 111 East Kilbourne Avenue is my office address, but we also have the property owner's address in the record. I used to be on the Wauwatosa Board of Zoning Appeals, so I concur with the chair that sometimes appeals of determinations or decisions are Rare or more rare than what you may ordinarily have. And sometimes it's nice when the clerk calls and says there's no monthly meeting and you didn't even have an application for a garage variance, setback, or otherwise. But I work with my clients on land use and zoning matters in the local government domain, and enjoyed a very good working relationship with village staff here on a couple of projects. And on this one, I kind of inherited things, and I'll talk about my role, but I know everyone has a job to do and they're just trying their best to do it. The parties here are important just to orient you. And as residents of Germantown, even as you get to the border and edge areas of Germantown, I'm sure you're familiar with the Fleet Farm on County Line Road and Appleton Avenue, surrounded on one side by Menominee Falls and just on the edge of the village. My client, County Line Road LLC, owns the entire property. Fleet Farm is their tenant, and as a long-term tenant and leaseholder, which is very common, Fleet Farm has a lot of say in what goes on the property. They have invested in its property. They very much like their location here in Germantown. Property is current with all their taxes paid and the like, but it's common to have a complicated lease and that master tenant having a lot of say in what's going on. My client, though, was able to look at that parking lot as part of kind of a backstory here. And this is going back 15 months to August of 2023. And that well predated my involvement, but my client applied to create a new parcel, certified survey map, and site and building plan to put a Chase Bank in the outlot parcel, which is on the site location map in red showing right there. So a very common underutilized part of a parking lot. My client, the property owner, was able to get Fleet Farm to agree. They wouldn't object. They wouldn't have any issues with having a new building right there. And for the village's purposes, certainly good on multiple fronts, both for your tax base, as well as another service and an amenity and another business and some jobs coming to a brand new Chase Bank. I drove by this evening. Brian said he went on Monday. They're almost fully enclosed. I think a lot of windows are in, but there still is some plastic. So they're making great progress with the construction. Building permits have been issued long ago, and Chase is looking forward to opening. My guess is probably within the next 3 to 4 months. But that's inaccurate testimony, right? I don't have personal knowledge. Chase is not my client. Again, my client, County Line LLC. Fleet Farm, not my client, but the tenant of my client. And then Chase is who submitted the applications and is building the building. With that, then consultants involved. My client is the landlord and the property owner. Chase was responsible for obtaining its permits and all of its approvals. So they had the Architects Partnership, TAP, is who submitted all that back in August of 2023. And Chase also works with sign companies called SignTech on a national basis. And as is common with sign companies, they oftentimes will ask a local installer to either help with the permits at the local municipality, as well as ultimately when it's time to hang and install the signs, have that local installer. So SignTech is Chase's sign company, and Lemberg Electric was working with SignTech. At some point, and I'll get into the timeline very briefly in a moment, but at some point, my client, the property owner, and Fleet Farm, as signage was being discussed, as it was supposed to, did have another sign company become involved, and that was Elevated Identity, and the gentleman's name for that, Mike Kinsella. Elevated Identity is a local firm, has had a lot of experience in Germantown and elsewhere. What that introduction is all about, the prelude to all this is, it took me probably until yesterday afternoon to put all the pieces together, asking multiple parties for copies of emails and plans and how confusion could have occurred. I do acknowledge the frustration and definitely confusion of our team in a way, or what our team on confusing side has exhibited on village staff. And I frankly haven't talked to them directly about it, but this is my chance also to apologize after acknowledging that, you know, I think service consultants, teams like this can do better, and we should have done better. And, you know, that's certainly, I'll put it this way, because staff has worked with me before. I wish I'd been involved earlier. I don't think we would have gotten to this point. But I really only became involved right before filing the appeal, because 30 days was fast ticking. So say September of this year is when I first became involved. And tried to work some things out, but as I quickly realized, there's a lot of baked details and history on this one. And so the easy thing to do with that 30 days was to file the appeal that's before you. I'll talk about the ordinance in a minute, because of course that's important. But really it was, I have 3 sentences in the appeal. It was the quickest appeal and simplest, because there's no reason to make it overly complicated on this one. We're not looking to start World War III. We're not, going to major litigation on stuff like this. It's really quite simple. So what we're appealing, and I guess let me take a step back and talk about the ordinance. So in reverse order, the pile I gave you, I have a timeline, which doesn't have an exhibit sticker, and then I have exhibits A through G, and then the back one is a copy of the ordinance. And again, I did give village attorney copies, and if you need to share with staff as may be needed. I'm not going to cross-examine people on who wrote what and when, but let's start with the ordinance, because to the chair's point, this is an appeal that we need to focus on. What our appeal is really under your zoning code, which was in the packet, I believe, the dark gray, we're, I believe, under 17.52 sub 4, appeals. And it's of an administrative determination of the zoning administrator, not really, the building inspector, or the plan commission concerning the literal enforcement of this chapter, et cetera. And so here, the plan commission in August of this year on the sign permit applications made a determination, which for your reference, the copy of that is my exhibit F, which is, rather than the whole meeting minutes, I just chose to use the notification of action by the plan commission. The village does a very nice summary document that goes to the applicants. This one happens to be dated August 15th of this year, related to the August 12th meeting date. And what we are appealing is the second bullet point. It says action taken, underline, long paragraph, 1 bullet point, 2 bullet points. The bullet point of the action taken was prior to issuance of an electrical permit and installation of the Chase Bank signs, the existing non-conforming pylon sign advertising Fleet Farm and its gas prices, which fronts the property at the corner of County Line Road and Appleton Avenue, shall be removed. This was a commitment made by the applicant in 2023. Some details about the discussion that followed, that passed unanimously. Kind of glad Mr. Baum, Commissioner Baum left. He might want to give more color to it, but I think the record is all I want to focus on with respect. That's what the Plan Commission decided in August of this year. And we are appealing that condition that I just read in, related to the Plan Commission not having the authority or the jurisdiction to require the removal of the pylon sign in the context of the Chase sign application, which is for 4 wall signs and 2 directional signs on the Chase parcel. And I would just add to it, the other legal standards. It's an arbitrary and capricious decision or condition added by the Plan Commission. It exceeded the authority. It acted contrary to law and outside of its jurisdiction, and was unreasonable on its face, and also anti-competitive. And I'll get into that in a minute about what contextually is going on in that area. Those, to me, are the appropriate standards. We don't have, like you just did with the variances, a variance of 4 specific criteria that come out of the ordinance. What it really is, and again, back to your gray piece of paper here, 17.52 sub 4 appeals, it doesn't give any express standards. So I'm going to suggest to you that those general, what's reasonable, was the condition arbitrary, was it grounded in the law? So that brings me to my back page handout, 17.46, the sign ordinance. Because again, what's at issue here is not the Chase Bank, not the approval a year ago. And it may be relevant, we'll talk about who said what and when, but what's at issue is the application for 4 Chase wall signs and 2 directional signs, and then the Plan Commission tagging on the pylon must be removed in the context of Chase's request and its investment. 17.46 sub 1 of the Village Code that the Plan Commission should be following reads as follows: for intent and purpose, the intent of the section is to provide for and regulate the location and safe construction of signs in the village in a manner that will ensure that signs are compatible with surrounding land uses, and to express the identity of individual proprietors and the community as a whole. And the last sentence, all signs, unless otherwise specified, shall be approved by the Plan Commission. Plan Commission clearly has jurisdiction and authority to approve signs. I think the standards are in the next paragraph, but it also includes what's above and references to the compatible with surrounding uses. As you may know, in this very busy corner, the bank to the south, I think it's the Tri-City Bank, has a tall sign, a couple of tenant panels around that. That I believe is in Menominee Falls. But on the Germantown side of the municipal boundary, to the west, Tires Plus and Batteries Plus are single tenant buildings that are pretty tall. Menards farther down the way. Maybe west is north. I'm sorry, I might have gotten that confused. But either way, the Tires Plus, Batteries Plus, Menards has a single tenant, pretty tall sign. And then, of course, the strip center right next to us is a very tall sign. I know the code, and staff, I'm sure, can explain it all day long and every which way. A multi-tenant building can be taller under the code, but the fact of compatibility and what's around us, the fact is there are some taller signs. We are not an outlier with the existing pylon sign. It also helps to express the identity of the individual proprietors. As I drove on Appleton Avenue this evening to the southeast from the northwest, really you cannot see the Fleet Farm building. What you can see is the sign, the pylon sign that's existing. So there is grounds in the code as far as the identity of who's on the property and what the intent and purpose is. The second paragraph really, I think, gets into a little more detail on the standards of what the Plan Commission should have applied. It shall consider the purpose of advertising, the appearance, location, lighting, height, and size of the sign, safety of the operators of vehicles upon adjoining streets and highways, the effect of the sign on property values within the immediate area, and the effect of the sign with respect to the scenic beauty of the vicinity in which the sign is proposed to be located. First point on all that is, before the Plan Commission was not an application at all to deal with the pylon sign or a monument sign for that matter. So in a way, the Plan Commission, once it veered outside of the lane of those six signs, the applications that were submitted, it's starting to factor in. But I certainly can address the pylon sign, and I would argue to you that the pylon sign is serving a purpose, and it's not detracting from property values given the surrounding context of other signs that are that tall and things of that nature. Perhaps more importantly, under the sign code 17.46 is if you flip to page 10 of that handout, 17.46 sub 13 references existing signs. And it reads, signs lawfully existing at the time of the adoption or amendment of this section may be continued even though the use, size, or location does not conform with the provisions of this section, provided, however, that such signs shall be deemed a non-conforming use or structure where the provisions of section 17.48 of this chapter shall apply, except that a replacement sign face with the same or nearly identical sign face may be approved by a permit of the zoning administrator. So if the Plan Commission wanted to peel back the layer and say, well, let's talk about the pylon sign, they should have concluded that that was a legal non-conforming sign. I think the staff commentary even says and calls it that, but there's no authority in 17.46 to, in the context of other sign applications, mandate that the pylon sign be removed. And I know the reason why all that came up. I'll get to that shortly, but the key is, what does the law provide? And in this case, the pylon sign should qualify under 17.4613 as an existing legal non-conforming sign. And the standards that the Plan Commission was to apply should not have allowed it to reach out into an area that wasn't before them based on the applications. And all that's in the bigger packet. I don't want to get too far into those details. The last thing I didn't actually give you a copy of, but I just noticed when I was sitting there during that other item that 17.4613 bridges to 17.48, your legal non-conforming. And so I will just read this for you. The village attorney can confirm, or you can look it up in the code online, because that's literally where I got it to email to myself. Because it's important. Such signs shall be deemed a non-conforming use or structure where the provisions of 17.48 of this chapter shall apply. So 17.48, I want to make sure that applies so that my argument stands through on this. 17.48 sub 3 says existing non-conforming structures. We would agree the pylon sign's a structure. A, general. The lawful non-conforming structure existing at the time of the adoption or amendment of this chapter may be continued, although its size or location does not conform with the lot width, lot area, yard height, parking and loading, and access provisions of this chapter. However, such a structure shall not be extended, enlarged, reconstructed, moved, or structurally altered except when required to do so by law or order so as to comply with the provisions of this chapter. That doesn't say the pylon sign has to be removed. Now, maybe someone will argue and trying to defend what the Plan Commission did. Well, the law and the order is the Plan Commission saying and adding that condition. But I think that really starts to turn legal nonconforming uses of a structure like this on its head. And so I would not concede that that's what that final sentence means. What my argument is that the pylon sign clearly is an existing sign under 17.4613, and it passes muster of what is required for 17.48. With all that said, and to really just cut to the chase of my first point, and again, going in reverse order, what I would point you to is consistent, I think, with that determination, which is Exhibit G, an email exchange starting at the bottom of page 1 from Mr. Retzloff on August 19th. So this is a week after the Plan Commission meeting. First paragraph isn't really applicable. The big one on the second page, top of page 2 of Exhibit G. But the concluding sentence is our argument. This is what we are looking for as a remedy. Quote, if Fleet Farm wants to keep the pylon sign, they can continue to use it as is, but cannot make any modifications. End quote. I'm not here to present a variance. I'm not here to present a new sign. Lord knows there are enough new sign scenarios that were in the record before the Plan Commission. But that statement is what we believe, that we know the Fleet Farm sign can't be altered, it can't be moved, it can't be enlarged, it can't be touched. And that's fine with my client, the property owner, Chase Bank, and with Fleet Farm. And with that being an understanding, and the way I believe the law for the ordinances I just read to you, and even staff before I was involved back in August saying that, to me, that gives you the ability to very easily grant our appeal, say that condition requiring the removal of the pylon sign was unauthorized, was unreasonable, was without jurisdiction, just because they're already covered. That sign is covered. And that ends my argument, that ends my night. I certainly am happy to talk a little about how we got there. Again, the frustration, the confusion we caused, the frustration by staff. Yes, there were different sign plans submitted. Yes, Chase showed a new monument sign and all that. But that really gets into, as you can imagine, a complicated structure of property owner, tenant, new party to town, whose sign company was driving the bus. And again, I recognize that was probably frustrating for staff. While there were many good intentions on our team and we think we were trying to do the right thing, the ball was dropped on our end. But at the end of the day, the sign package for Chase only asked for 4 wall signs, 2 directional signs, only had those cut sheets identified, and that's all the Plan Commission should have acted on. I'm going to pause. I guess I don't rest my case yet, because again, there might be more relevance to the fine level of detail. I know why there was a version of another sign submitted. I know what the different sign company, Elevated Identity, was trying to do. They expressly acknowledged that they would need a variance. Maybe we'll be here again someday. But the action tonight, we really, I recognize it's very narrow. It's about that condition the Plan Commission set requiring the removal of the pylon. And if the board knocks that out, then presumably village staff will issue the Chase signs. Building's almost done. It's really moving along. Chase will be able to open, and then maybe without the spotlight or the handcuffs of this procedural history, the right parties can come together and maybe the pylon sign stays there. It can't be touched, or maybe there's a new version that can be worked out and worked through that I admit might need a variance. And the Elevated Identity guy, Mike Kinsella, thought it needed a variance. He was asking for the form from staff and all of that. So we know we weren't promised anything. We know we're not entitled to anything, but we are, other than entitled to keep the pylon sign standing as it is, even if it's not the best sign in southeastern Wisconsin. Thank you. Happy to answer questions.
Somebody, I'm waiting to hear from Mr. Sadak and to try to formulate any, but go ahead. If you guys have questions now, please ask.
No, I'm in the same position as Mr. White.
If you could just The word that keeps coming to mind in my review of this prior to the meeting tonight and while listening to your case is the word reasonableness. It appears to me, and maybe if and when you get into the details, or maybe when Mr. Sadek speaks, my answer or my questions will be answered, but it appears to me that the village assigned a condition to the sign agreement, if you will, in the 11th hour. And so my question goes to reasonableness. Is there anything to conclude your case to this point? Is there anything that you would want to comment on to that word, reasonableness?
Yes, and I appreciate that question because I think I can elaborate a little bit, and reasonableness is part of my objection. And I think it is fair to call it at the 11th hour because the key, and I don't have to quote things for you, but and as, again, a year ago, November 13, 2023 is when the site and building plans were approved by the Plan Commission. Exhibit A, throughout that, there probably are some highlighting, and we could put things up on the screen bigger if you ever needed to read it, but the highlighting shows, quote, existing sign to remain, existing sign to remain. It's all over the packet of Exhibit A, which was the site and building plan. And Exhibit B are the meeting minutes, and my timeline gives some of the quotes. Yes, there was a discussion with Director Retzloff and with the TAP, that was the architect representative. Sign company's not involved, but yeah, everyone's talking about, we can probably work on that sign. Fleet Farm sign, absolutely, we can work on that. But there was no commitment or requirement by the applicant. Again, the applicant is TAP, which is Chase, not the property owner, not Fleet Farm. And the Plan Commission at the time didn't make it a commitment or a requirement. So reasonable, certainly November of 2023, let's all work together. And that is then what I think maybe unbeknownst to village staff, but the private parties did start to work together on, well, what would that sign look like? And Chase had their ideas. And then, as you might imagine, when Fleet Farm is approached, they're like, well, here's what our issue is. Like I testified to earlier, really from the driving to the southeast, you really can't see Fleet Farm. And I think they wanted prominent signage or to retain some element of it. And to bottom line it, they probably in some way are like, we'd rather just keep our tall, not so pretty sign versus have a short sign that no one can see. So that's the internal machinations going on. The back and forth then goes on for several months. And to the point of reasonableness, though, I would draw your attention back to Exhibit F, which is getting us to the Plan Commission of this year on the sign package. And again, the sign package has an application with 6 applications, 4 wall signs, 2 directionals. The application, the sign set that was submitted by the sign company did not have any new monuments. I think the Plan Commission packet had that set swapped in. Either staff did it or they mistakenly did it. Don't know. We had a lot of confusion going on. But the reasonableness part comes to what apparently the discussion was, and this is what I highlighted on Exhibit F of the August 12, 2024 Plan Commission meeting, which in the middle, Tina Lewis then is the Lemberg Electric sign rep for Chase. She's asking, can we put our signs up on Chase, even if the replacement Fleet Farm pylon is not ready? Director Retzloff said that was a condition of the original approval for building Chase Bank on this site, and the sign in question now rests on the Chase Bank property. That was not a condition in any records I've seen from the prior Plan Commission. Next sentence. He said there have been several sign proposals for Fleet Farm signage that do not include removal of the pylon sign. That's true. So there has been no movement towards removal, and from the standpoint of leverage, we need to keep that condition in. The word leverage, I think, drives right to the heart of reasonableness here. And again, for the first time, the village is trying to exert its authority or get what it wants, exercise its will and not its judgment, are some of the legal standards that I would point to you on a review such as this. But leverage is a strong word, and I get the frustration and the confusion, and maybe it's the real word. Maybe that's true. They were looking for leverage, and by golly, they got it, because our side went crazy. because Chase feels like they can't open and they can't get their signs. Fleet Farm feels like it's being held hostage, and they never said their sign could be changed or altered. And my client is caught in the middle because he's the property owner, and he's trying to make this all come together for the benefit of the village, because this was an underutilized section of the parking lot and we could probably do better with the pylon sign, but that's a story for another day. So I think the nature of how the leverage was exercised and the condition was foisted in the 11th hour is, to us, also frustrating, but really what gets the legal standards of unreasonable. It's arbitrary. It comes out of left field. Admittedly, it's not totally left field. It's been talked about for a year. It's on the property. But the standards at play for the Chase sign package, Chase isn't on this pylon sign. Chase isn't going to put its banner up there because we know we're stuck with that sign as a legal non-conforming use.
That helps me. Thank you.
Thank you.
Mr. Sadak?
Good evening again. I'm going to actually start with a fairly simple question to Mr. Retzloff. And then I'll kind of jump into some of my thoughts on what's here. We've heard a lot of talk, Mr. Retzloff, of that initial site plan application and discussion of, there's the monument sign that's there. It's going to stay. It's not going to stay. What I guess was going on at the time of that application that might shed some light on, if anything, on kind of the mindset of what was going on as you entered this application process?
Well, as far back as September 2023, we've been involved with sign contractors discussing sign issues, changes with regard to the Fleet Farm property. It was in mid-September of 2023 that we actually approved some sign face replacements for a number of signs on the Fleet Farm property. But we also denied a couple of requested changes to the non-conforming pylon sign for Fleet Farm. And I put together a fairly elaborate letter explaining to the sign contractor why the pylon sign was non-conforming, why the changes they were proposing necessitated removal of the pylon sign pursuant to the terms of the non-conforming structure provisions in the code. And so that was sort of going on right at the time that the applications were received and being reviewed by village staff for the site plan and the certified survey map. Typically, as part of a site plan package reviewed by the Plan Commission, signage is included. And so through emails, phone conversations with the sign contractor, I'm asking, okay, what about the pylon signs? Because what you're proposing is creating a new parcel that would effectively move the pylon sign from the Fleet Farm property to the Chase Bank property and making it, by way of the sign code, an off-premise directional sign, making it another level of nonconformity to that particular sign. So it not only is it foremost on my mind, what are we doing with the pylon sign now that it's on the Chase Bank property that's now proposed to be developed? What's going on? So when I ask the contractor for the Fleet Farm sign face replacements that we had just approved, what's going on? I don't hear from that particular sign contractor, somebody named Jamie Hugel from Expedite the Deal, one of the many sign companies that have been involved in this process. She eventually says, I'm no longer working on that project. So when she tells me who is, and I contact Jamie Westfall with Lemberg Electric and saying, I understand you're now involved with the Chase Bank and the Fleet Farm sign issues. Here's a couple of questions. What about the pylon sign? What's going to be happening with that? And her response effectively is,
the Chase and Fleet Farm are working together on coming up with an alternative sign. Okay, but it's not ready for permitting, so it's not going to be part of the package that is submitted for Plan Commission review in November of 2023. And that's when the staff report, the copy of which I believe that was part of Brian's packet, contains a phrase in there that basically says, there's a non-conforming sign for the Fleet Farm. It's on the Chase Bank property. The applicant has committed to addressing the signs as part of a separate application. And meanwhile, what I'm hearing and what I'm seeing in the packages of sign proposals that eventually come through is on one hand, there's some graphics that show the monument, the pylon sign being removed, others showing it being modified. But at the time of the application, what's going through my head is we need to address the pylon sign if we can as part of this process, and that we've let everybody know it's non-conforming, and it really, if you're going to make some changes, let's take it down and make the changes.
And then one follow-up question to that. If you had been told that at that time, no, we're not touching the sign. We're going to leave it on the Chase parcel and it's going to continue to exist, would you have recommended approval of the site plan?
Yeah. Well, yes, we would have, but frankly, we probably would have included a condition in there addressing the pylon sign. The fact that at the time they were assembling the staff report and the sign contractor that's now involved is saying, yeah, we're working on a new design that will be within code. Okay, well then we'll let that pass through and we'll handle it as part of a separate permit. And that was the staff comment in the staff report. It was, in a way, it was taking to heart what the sign contractor was telling me, that they were working on a alternative that would meet the code requirements, but will deal with it at a later date. So we didn't include a particular requirement in the site plan application addressing the pylon sign.
So with that in mind, this whole situation to me, Attorney Randall at some point referenced, the ball, and what came to mind kind of immediately is this is Charlie Brown and Lucy. This is the applicant, the property owner, and the various sign companies that have been involved saying, here's this shiny ball, we're going to get there. And then you get to the end and you're at the last moment and whoop, pull that ball right out and you say, you can't do what you're talking about. The reality is that there was a lot of good faith that went into this. Obviously, the Fleet Farm is a long time business here within the village. The property owner, to my knowledge, has been the owner there, the entire time that has been there. So likewise is somebody that the village has dealt with on a regular basis. The nonconformity of the pylon sign is not a surprise to anyone. Has never been a surprise to anyone. With that said, I'm also in kind of a weird circumstance. We are appealing the decision of the Plan Commission as it relates to the sign package. And the record before you would be the record before the Plan Commission. What did the Plan Commission know? What did they understand? So we have a whole number of exhibits that have been presented that are private emails between staff and various sign companies that, to my knowledge, were not in front of the Plan Commission. Plan Commission had no idea that they existed or not. But at the same token, many of them, I think, help that concept that this was a situation where you had various representatives of the parties on the owner's side saying, this is where we're going. We're going to get there. We're going to get there. We're going to get there. And then when you get to the last possible decision that exists and you put that condition on finally and say, okay, we've kind of let you go all along. We could have put the condition on at the site plan. We could have put the condition on the CSM when the CSM was approved, but we haven't done that because we want you to be able to move forward with your project, in essence, trying to be the good government, business friendly, all of the great things that you hear, that we want our governments to be, and not, just obstructing some business owner in terms of what they're doing. You have to put the condition on somewhere. And this was the somewhere because this was the last potential approval that related to the property and the signs that were going on. The other piece of this is certainly, I mean, there's some hint that, well, we maybe didn't know that all of this was being discussed at the Plan Commission and was being contemplated as requirements that were going to need to come on. Remember, and certainly you can look at the packet itself. Within the packet on the 10th page of the packet is the sign review application. As you'll see in some of the exhibits as well that are provided, it's the same thing, but every zoning-based application here in the village requires two signatures. One is the applicant or the agent, if it's not the applicant, and then the other is the property owner. At the end of the day, we always want the property owner to know and be part of what's going on. And so as it relates to both the original site plan application, the CSM application, the sign review application that's presently before you, the County Line LLC, the representatives of the owner signed off on that application. They knew what was coming, what was going on. They've been part of the process all along. So with that said, I'm not unpersuaded by anything that Attorney Randall talks about. He's spot on in terms of the law, that you have certain standards and things that you need to do. And I think that at this point, it's really a distinction or an argument as it relates to what does the code provide and what are we legally able to impose as conditions on applications. So to that end, the first thing that I would point out is we talk about the sign code, and he provided a copy, and I know we also handed out a copy ahead of time. The one thing that doesn't directly get addressed is the fact that when we split this parcel and created the Chase Bank parcel, you took what was already a non-conforming sign and you made it more non-conforming. It went from a sign on a property to a off-premises business sign under the sign code. That's 47.46 sub 7. And that's the regulations as it relates to off-premises business signs. There is no question in my mind, and I don't think that there's been any argument on the applicant's side. In fact, I might suggest that their basis for the appeal maybe even recognizes this as they talk about the fact that, well, you didn't put it on the site plan and you didn't put it on the CSM, almost tacitly recognizing that we could have at any point. There is no question in my mind that non-conforming sign, if you wanted to take a request to rezone the property, to split the property off like we did here, to do any sort of situation where we were granting something that is purely discretionary at the end of the day, that we can condition that on the removal of what will be a more non-conforming sign. We already have a non-conforming sign. We're going to make it worse. We're not going to let you make it worse. We're going to make you take that sign down. And so as a result, you heard Mr. Retzloff say, I would have put a condition on if I knew that their position was going to be, we're just not going to deal with it. I would have put a condition on it. If they had come in with a sign package at the time, like is, as you heard the testimony, fairly standard, that you get the site plan and the sign, application that comes in at the same time, and you saw that that was the case, it would have been addressed at that point. But in good faith, the village says, okay, you've agreed that you recognize that this is an issue. We're going to talk about it. We're going to get to that point. And so you end up in a circumstance where there is no question that this requirement to remove the sign is a legal requirement. Now, Attorney Randall's going to say, well, yeah, but that was a requirement that you could have put on the site plan or on the CSM. It's not necessarily something that you could put on here. And to that, I would say that I think he's wrong. Certainly, if you look at, for example, the site plan regulations under 17.3 of the code, I'm sorry, I didn't print out a copy, but 17.43 talks about site plan approval and the requirements for site plan approvals. One of the things that section does in sub 3 talks about required site plan information. And it talks about having on your site plan things like the shape and location and height and floor area of ground floor elevations, natural features such as woods and lots, proposed sidewalks, streets, parking spaces, that type of stuff. But the one thing that's missing from that whole list is signs. Signs is not part of a site plan application proper because that's a separate application. It exists separately, but they're typically considered together. Likewise, if you look at the provisions related to CSMs, you're not going to find anything in CSMs that talk about you got to address signs as part of your CSMs. And so that leaves you in the position where the only application for which the signs are truly addressed and is truly subject to what's going on is the sign application. Now, again, in most cases, that application comes in at the same time as the site plan. So you're dealing with them at the same time, and you're able to say, yep, this is our condition. We see that there's these two conflicting issues that exist, and we're going to make that condition, and we're going to do that. The problem is here, if we had done that, they would have waited a year, maybe more. We're still, they've still indicated, yeah, we're still working on a combined sign that's going to meet the code, or maybe will require a small variance, but we're going to get you something. And we're still waiting, in terms of getting that. And so, if we had put that condition on the CSM or the site plan, that building wouldn't be sitting there almost finished as we're talking about now. That building would be still sitting there in a vacant parking lot because they haven't gotten the sign. Now, maybe we should have. Maybe that would have been the fire that sparked them to actually get us something that was compliant, and shame on the village for not foreseeing the fact that we were just not going to be able to get this done. Maybe that's fair. Nonetheless, when you look at the sign code, because that's what Attorney Randall is going to talk about, I think you look at the off-premise business signs and the regulations that relate to that, which you didn't discuss, and that becomes important because you, when you split off that lot, created an off-premise business sign. That off-premise business sign includes discussions within it that say, for example, that at the discretion of the Plan Commission, the incorporation of off-premises sign into an existing or new ground sign may result in a reduction in the number or size of signage needed to be displayed on properties or businesses benefiting from the off-premises signage. So certainly that code section seems to indicate that the Plan Commission has some discretion in terms of dealing with these off-premises signs. Similarly, the last provision of that section talks about the sign area used for the off-premises sign shall not exceed 50% of the total sign area. Now, I'll admit that that code language is somewhat inelegant. Total sign area of what? Of all the property, of just one property, of just the combined sign itself. It's not totally clear. I would submit that it's probably 50% of the combined sign that would be intended to be that off-premises sign. You don't meet that here. The off-premises sign at this point is 100% for the non-parcel that's there.
What section are you in? Just
That's 17 or 4746 sub 7 sub G.
7G.
It's
Let me just get to it.
page.
Oh, yeah. All right. I'm with you. Let's see. All right.
Where are you seeing page numbers?
Might be. And out.
Yeah.
G goes from 7 to 8.
And you're saying that there is a violation of that at this point? Percent?
Correct. I mean, effectively, the land division created an additional nonconformity as to related to that. And again, had these been addressed all at the same time, probably would have put conditions on all of them that said, hey, you got to deal with this nonconforming sign. We didn't do that. And so this is the last application in which the village can say, hey, we have some authority to deal with whether or not the signage on all of these various properties is appropriate. And we're going to exercise that authority in this case. Now, the Planning Commission certainly could have said as part of this application that, hey, you know what? You've got this off-premises business sign, and as a result, we really want you to look at the signage that's on the Fleet Farm property and maybe reduce some of that signage, because that's clearly an authority that they have here. It is the property owner as the applicant, or part of this. He owns both parcels. So, this isn't an issue of, well, this is an application by Chase and the property owner didn't really know, or Fleet Farm didn't really know. Now, certainly in the lease and the long existing relationship between the property owner and Fleet Farm, probably ruffling a whole lot of feathers, probably some very difficult conversations that have been going on about, what do you mean you agreed to split off the property and now I got to lose my sign? What were you thinking? Why didn't you talk to me? All that kind of stuff. But you know what? It's not the village's problem. That's for them to deal with and look at. The other thing that I would talk about is the fact that we talk about the intent and the purpose under the sign code itself. We read through it earlier, and it talks about the purpose of signage, and I think the implication was, as part of this, that it's certainly within the Planning Commission's realm to consider the factors that are here. The purpose of the advertising, the location, the lighting, all of that kind of stuff is all free game under this intent section. Can we put that last slide up, I think? No. One that shows that. So this is Google Street View. Nice of them to drive by a month ago and provide for us a pretty good example of what that site looks like presently. As you see, there's the Chase Bank that's being built there. It's got kind of the yellow wall with some vacant studs to the right side of it, and a big Fleet Farm sign in front of it. I would submit to you, whose sign is that? Who's it intended to identify? Because certainly I think anybody driving along that corridor, just as Attorney Randall talked about doing as he's going along, thinks that that's a sign for that bank property, not what's behind it, based on its location and orientation and everything else. Now, we can, certainly get into some of the other more esoteric concepts in the law. You talk about, there's this concept of regulations being, even potentially takings under the law. Exactions is what the legal term is. And there's a bunch of case law that talks about it. Famous case, Dolan v. City of Teagard, which is really kind of it was one of the first cases that wasn't like one of the foundational cases, Brown v. Board of Education or Marbury v. Madison that kind of everybody knows about. Dolan was one of the first cases that I had conscious knowledge of that came down that seemed to have some impacts, as at the time, a college sophomore, I think, if I remember right, thinking about going to law school, and this seemed like an important case to me. And it turned out I was right. It's continued to exist and cited routinely. That case talks about the idea of the unconstitutional conditions doctrine. Says that, in essence, that you cannot, as the government, require a property owner to give up one of their rights in the exercise of granting some sort of discretionary benefit. Certainly, you could argue that that's what's going on here. You signs are speech, First Amendment, yay, right? And you're forcing them to give that up. And so what the doctrine says and what the case law talks about is that there needs to be an essential nexus between a legitimate state interest and the permit condition or the requirement, the exaction that's there. In this case, the legitimate state interests are all the things that we talk about in the intent and purpose, the need to provide safe construction and location and lack of confusion and all of those types of things that go into typical sign code regulations. The request here is, you got to tear down the one sign that doesn't exist, but we're going to let you put it up with a combined sign that's got 2 tenants on it. So a pretty clear nexus, logical basis that, here's our concern and we're going to address it by doing this. And the case law talks about, there being a general rough proportionality, that they can't be, the burden can't be so high for a very small benefit, for example. And in this case, I think you meet that. Again, we're not saying you don't get a sign. We're just saying you got to tear down the non-conforming one and replace it with something that conforms under the code. That's the requirement. And so I don't know that we fall into those things. Similarly, you talk about some of the very standards that you folks have to deal with. Did you exceed the law? I don't think you do. You've got a couple instances, I think, within the code that clearly talk about our rights to do this. Likewise, I think even outside of the code as it relates to this very specific application, when we look at that concept of again, Lucy pulling that football out from poor Charlie Brown, you've got a point where we clearly could have put this condition on. Nobody disagrees with that, I don't think. And the fact that we allowed them to continue to do the construction, that, hey, we're going to work on it, we're going to get there, don't worry about it. All under the assumption that we were going to get to some point that we were going to get what the condition ultimately was designed to do. When you get to that last point and it's not there, you got to do it. Now, we talk about reasonableness, right? This isn't reasonable. You came to me at the last minute and threw this on me. I think it's pretty clear by now that this wasn't the last minute. This is something that's been talked about. I mean, even the exhibits that I say may or may not relate because it's not really on the record before the Plan Commission. It's clear from those that there had been tons of discussion by the various parties that were involved here of, hey, we're going to fix this. We're going to make this sign compliant. It's just a matter of trying to figure out the design and who's going to get the bigger sign or whatever the issues are. I don't know. But this wasn't us coming in at the last minute and saying, surprise, we're going to do that. In fact, I would argue again the opposite, that this was, a property owner and some tenants of that property owner who said, yep, we're going to get there. Trust us, and then get to the end. And the comments I made, I couldn't think of where it actually came from, but I remember as a young teen, the phrase "psych," very much kind of what it seems like. That you get to the end, and yeah, we were just kidding. We're not going to do it. And so, with that, I think we clearly meet the standards. We're within the code that's there. This isn't something that was arbitrary or capricious. It's based in the code. It's based on very real concerns that exist within the code. Something that clearly we could have done at any point along this process. To punish the village at this point, to say, well, you did it at the last minute, and so that in some way negates that action, I just don't think is accurate under the law. Do you have anything to add?
Well, I would say this, as Mr. Randall pointed out, there was a lot of confusion going on throughout the entire process. There were actually 5 different sign companies that had contacted staff over the course of the last 18 months about this particular project: Fleet Farm signage, Chase Bank signage, combination signage. And certainly, given that, I can rest assured that it wasn't calculated or contrived. But the situation sort of turned out to be one where, we've all seen those circumstances where somebody goes to buy something like a car, and they look at it and it's got all the bells and whistles, and they're about to sign the contract, and they ask, does it include this option, and does it include that option? And the answer is, oh yeah, sure it does. And then he signs it. Few weeks later, months later, maybe a year later, takes delivery, and it doesn't have those options. And he goes back and he asks, well, you told me that this option was in there. And the guy said, well, look at your contract. Does it say that option was in there? And it's a similar situation where the property owner now is saying, I never agreed to removing the pylon sign. Show me where I wrote down in an agreement with the village or others that I was going to take that pylon sign. Well, that may be very true that the property owner didn't, but the agents that were acting on behalf, the 5 different sign contractors that discussed this whole process, at one point or another, were saying things like, yeah, they've got that worked out. Chase and Fleet Farm, they're getting together and they're going to come up with a code compliant sign, a multi-tenant pylon sign to replace that one. So the little placeholder that shows on the site plan, that's not going to be the pylon sign. It's going to be a replacement one that meets the code. And so we go along with that. And as Brian pointed out, his Lucy football analogy is another one. You get to the end, the swinging of the foot and trying to kick the ball, and it's like, no, it's not there. It's not down. The sign is still there. There's not a commitment, and so it's not a reach for the village to say, hey, take this sign down and let's work on getting one that's code compliant, like your sign contractor said you were going to be doing. And that's ultimately what was done as far as the staff report and the plan commission decision.
I've got a couple of questions for Mr. Sadak. Well, let me ask this. Could the plan commission simply have did they have the discretion to just deny the Chase sign application?
I think that they could have.
What do you, Mr. Randall talked some about an arbitrary and capricious standard. What do you think, or is that the legal standard that you think applies to the actions of the plan commission in putting a condition on the approval?
I'm chuckling a little bit just because of the phrasing of the question. I would not say that the actions of the Plan Commission in this case were arbitrary and capricious.
No, is it?
But I do agree that as the standard of review here is not unlike, and sorry to the non-lawyers of the group, but it's not unlike the certiorari standard in a typical certiorari action. So the will and arbitrary and capricious type concepts are clearly part of that.
Okay.
And what's here. I just don't see that this is arbitrary at all. It's consistent with all of the code
No,
regulations.
I'm just trying to understand the standard that to be applied. We have to, at some point, I think, make a determination as to whether the Plan Commission had the authority to impose the condition. And I'm trying to figure out, so I'm asking you, because Mr. Randall was the one that introduced the concept of arbitrary and capricious. Is the question whether or not the condition is arbitrary and capricious? And I'll come back to you in a minute. Or is it something else? Or is it that plus something else?
Certainly my thought is that the question of whether it is arbitrary and capricious really falls under the bigger question of, are you acting under the law? Are you authorized to do this?
Okay.
And that my reading of the various cases on that kind of standard are that when you get into, do you have the authority to do this? Are you acting within the law? That some of the things that you look at in trying to determine that is, is it consistent with the code? Is it just arbitrary or capricious, something that doesn't make any sense? Is it it's exercising its will, in terms of what's here? Those are all factors I think that fall under that bigger question of just, are you operating and was the decision consistent with their responsibilities?
I would think, that if the Plan Commission doesn't have the authority, then you never get to the question of arbitrary and capricious. It would seem to me that the whole concept of arbitrary and capricious applies to the exercise of discretionary power.
I would not disagree with that.
Do
No.
you disagree with that, Mr. Randall?
No, the last part of the statement, I
Okay.
would agree with that.
And then, all right. Mr. Randall took us to section 17.48, which was the non-conforming uses and structures. And as I looked that up on my computer, I see right below that is 1749 architectural control, which says that the Plan Commission serves as the Architectural Review Board. Does that factor in here at all? Does that provision give them the power to say, we don't like two signs there? That's unsightly to us. Does that power ever come into play in this dispute at all, or not?
Allow both of us to review that code section. So that's an interesting question. I have the practical answer, which is I'm going to turn to Mr. Retzloff and see whether or not we ever exercise the architectural control as it relates to signs. But I certainly, from a pure legal standpoint, I look at 17.49 sub 3 sub D, which expressly calls out signs. No building or sign shall be permitted to be sited on property in a manner which would unnecessarily destroy or substantially damage the natural beauty of the area, particularly insofar as it would adversely affect values incident to ownership of land in that area, et cetera, et cetera. That's the only reference to sign that I quickly see there. So, my initial, when you asked it, before I read the code, my thought was, no, architectural control typically is just buildings. So I was a little bit surprised to even see a sign referenced there. But I guess from a practical standpoint, I guess I don't know. Does architectural standards typically apply to signs, or is that more of a building issue?
The answer is yes. Specifically, if you look at the intent section of 17.46, the sign regulations, it says, in considering a sign application, the Plan Commission shall consider the purpose of advertising, the appearance, location, lighting, height, and size of the sign. So those are all, architecturally related appearance. What does it look like?
Yeah.
Sort of reasons and criteria to consider when looking at a sign. So it's more under this section that they're doing the architectural review than it is the other section that the chairman referred to.
This will be my last one, and then I can turn it over to other folks, and it'll be for I think probably both of you. Are we in this proceeding trying to determine whether the Plan Commission had authority to impose the condition? Or are we reviewing the action of the Plan Commission to see, and it strikes me as a slight difference, because, for example, that I can't tell from the record in front of us if the Plan Commission, and it sounds like they didn't, actually, in considering a sign application, considered the purpose of the advertising, the appearance, the location, the lighting, the height, or exercise whatever control is given to it by 17.49, the architectural control. And so I guess my question is if we think the code gave the Plan Commission power to impose this condition, but they didn't do it under the section that we think they had control, that they had the authority to do it under. Are we reviewing their action, or are we just reviewing whether we think they had the authority to do it?
My answer to that, and I suspect you're going to get a different answer when you talk to the other Brian, is that I look at the application to answer that question. The application says, and this is page 29 of the packet, page 3 of 5 of the Board of Zoning Appeals application itself. That page starts, you identify the purposes of the appeal, and then you get down to the decision or order is erroneous because. And that section talks about some of that history of, well, you didn't do it at the CSM and you didn't do it on the site plan and the village board didn't do it. But then ultimately concludes with the final sentence, which is the Plan Commission was without authority and jurisdiction to impose the condition for the removal of the pylon sign. So certainly as we or I and village staff prepared for this evening, we were operating under the impression that it was just hey, you didn't have the authority to grant this condition. And that's somewhat consistent with various other factors that went involved, the conversations I've had with Attorney Randall, the fact that his predecessor for a brief time had threatened us. I think like the next day after we issued the decision, we got a nasty letter that said, we're going to sue you because you don't have the authority. So I think that was their intent. Now, you may get well, yeah, but we also want to talk about that other stuff. But at least under the application, I think the thought was that it is purely you didn't have the authority under the code.
Based on what's written in the application, Mr. Randall, that sounds pretty persuasive to me. What's your thought? That really the only thing you're appealing is whether they had the authority, not whether they improperly exercised the authority or some type of review of the action. But what's your thought on that?
I agree. Brian and I agree the application on appeal was written specifically, it's challenging the authority. So I don't have to respond to something that Brian said earlier on the appeal. I don't believe you are sitting as the plan commission tonight. I'm appealing the condition they tagged on it underneath the ordinances that are out.
Got it. And I said I wasn't going to ask any more questions. This, I promise, is the last one. Do you agree that the village could have imposed a condition of removing the pylon sign as part of the approval of the site plan or the CSM?
I was also going to address that.
Sorry, could you repeat your question?
Yeah, whether, because there was talk, and some of the packet material said that it was a condition of the CSM and approval of the site plan. And now we hear today, it wasn't that specific, that concrete. And so my question to Mr. Randall is, could the plan commission or the village board have said, all right, we'll approve your site plan, or we'll approve this CSM and let you carve off that separate lot, but in order to do that, you've got to agree, we're going to put it in the CSM or in the site plan that you're going to take down the sign. Could they have conditioned approval of the site plan or the CSM on the removal of the pylon sign?
And it might surprise you with my answers, because in a way, I agree they do. First thing I'll say is, I like working with the village, and I don't want to suggest that the staff needs to be wary and tag conditions every which way early on and be hard to work with. And so, you know, I think this whole scenario is unfortunate, but the answer, I believe, is yes, that if the parties in November of 23, either in the context of the site and the building plan approval, which those plans clearly said existing sign to remain, that's all over exhibit, which one is that? Exhibit A. Those plans clearly said that. If it was that important to the planning commission and the staff, it may have been reasonable to put that condition out there at that time, and it might have been reasonably complied with by the parties who then had time to work it out. It's kind of weaves a number of arguments together that, you know, the village attorney, I think, the village wants their cake and eat it too. He admitted they wanted this project to start. You now have probably a $4 million building there. So January 1 is going to have a nice assessed value, and then it'll be open next year. They wanted the building to get going. They didn't want to be waiting for the big boys here. Fleet Farm, Chase, who's going to make this sign? How long is it going to take? The reality is it took us a while. And I think the record will reflect, and it does reflect, that we never pulled the ball away. We weren't playing games. It was going to take a while. And unfortunately, at some point, staff was legitimately frustrated, but exercised leverage. They used leverage to then become arbitrary of when they used it. That's where I'm arguing the condition and when it was applied was unreasonable. That's when it was arbitrary and capricious. It was exercising a will and not judgment. And I'll address some of the other things later. But I really believe that site and building plan could have been when it was reasonable, or certainly, as you're hearing the testimony tonight, and again, I'm going to be careful. I'm not going to admit there's a flaw to the certified survey map, but it seems as though the village is taking the position that the certified survey map shouldn't have been approved with this structure suddenly becoming an off-premise structure. Although I disagree, because I think the off-premise sign chapter clearly says that off-premise signs are allowed. 17477G on page 7. Ground signs located on a particular property serving businesses locating on that property may incorporate off-premise signage benefiting one or more other businesses not located on the property. And if it was determined as met by the plan commission. To me, that's key, that the plan commission decided to exercise its will. There was no application for an off-premise sign at any point here. And so the standards that Brian read in, I think really are only relevant if there's a sign application. And so just to conclude the thought, because I want to get to the sign application, I'm crossing off a lot of things that, you know, he said, and I appreciate you hearing us out. Like I tell my particularly young attorneys at my office, it's great when you have a good lawyer on the other side, because the bad ones make your job harder. And I'm actually having fun. He's made some good arguments, and I hope he might admit that I made some good arguments. We don't want to take your whole night, but it's important to both of our clients. So I think the certified survey map could have been the appropriate time. And mind you, this went to the plan commission, recommended, the village board saw the certified survey map. No condition in the record related to this. And the other thing to point out, I do think the record reflects not a commitment by any of the parties, the various applicants. On Exhibit A, page 4, which is the staff report from November of 2013, the staff report says the existing non-conforming Fleet Farm pylon sign along Appleton Avenue is, will be located on the Chase Bank parcel once created. True. The applicant has indicated that Chase and Fleet Farm are considering a new code compliant monument sign and electronic message center would be blah, blah, blah. True. Considering, that's not a commitment. In the minutes and the meeting recording, there's no commitment by TAP. There's what everyone was acting reasonably to say, yeah, we're going to work on that. That's not an easy one. That's an old sign. It's very important to them. It shows gas prices. I think that's a legal requirement for their fuel center. So a lot of moving pieces there, but there was certainly consideration and good faith in that as well. And for that, I would point you onto the timeline, which is where Mike Kinsella came in on page 2 of my timeline. You'll see a whole bunch of dates in May where Mike Kinsella of Elevated Identity met with staff, took surrounding site pictures, presented some plans that showed a new monument sign that showed both properties. Again, I don't want to get into what it could have been. And frankly, what I even presented to staff in September went nowhere. The reality is no minds could be met. There was no meeting of the minds, both on the private party side, but ultimately the good faith is documented here in May with Mike Kinsella and then with other parties. Ultimately, the reality is Chase looked at it and said, we want to build this building. June 10th, they submitted the sign application. And that's where I think it's also important to look at them when we talk about what's the authority, what's the jurisdiction. In your packet for tonight, the board packet, Brian referenced this. It is kind of hard to read, but this box is what's key. So the sign applications, yes, the owner signed these, and yes, the owner signed the ones for the site and building plan. Those sign plans or those site plans always said existing sign to remain. This sign review application, page, it says 10 of 33, so maybe I only printed a few pages, but 10 of 33, sign D01, that's a directional sign, gives you the details, paid for under $275. Next page, signs D02, directional sign, we're up to 2 directionals, like I said. Page 12, B01 wall sign, specs, another, actually that one's crossed off, so I guess we started applying for so many signs, we didn't have to pay all these extra fees. Page 13, B02 wall sign, 2 wall signs, 2 directionals. Look, I'm on Survivor here, whatever. B03 wall sign on page 14. 3 wall signs, 2 directional. Sign review application B04 wall sign, page 15. There's no pylon, there's no monument, there's no application. So my argument starts with the planning commission's jurisdiction was framed by what was applied for. And when this came in, June 10th is the date it was signed. I don't know the exact date, because if you notice, the sign company signed it back in April. As the timeline shows, there were constant discussions with staff, but at this point, Chase needing to move, they like, well, we know we need building signs. And to one of the questions earlier, the building signs comply. There's no dispute. There was no debate over the 4 wall signs and 2 directional signs. It's a Chase Bank. Great. Put them up. So that's where I think jurisdiction comes in on how the applications, maybe when a condition could have been placed, but not at this time in reaction to these sign applications. I think when the village attorney starts to spin into these other code sections, grabbing and pulling them in, I think that's where it becomes, again, unreasonable. To respond to one of those on 17.49, which is the architectural control section. First, sub 1, it suggests there should be an architectural review board. I guess that's the plan commission if it's invoked by this, the provisions of this chapter. Sub 4, administration involves the building inspector and a building permit application and referral to the plan commission if it doesn't comply. That's not what we applied for under Exhibit A back in November. Site review application is 17.43 of the code under site and building plan. And then we were applying under the sign code. So I don't concede that the architectural review stuff, even as clunky as that exhibit, that paragraph D said it says the word sign, but I don't think the authority from that was ever invoked because I've never appeared before and I've read minutes from an architectural control board review by the plan commission. So I just wanted to address that, at least to, preserve the record and to cover all this stuff. And maybe I'll stop here because I know I took liberties with answering the chair's question of, do I agree that condition could have been placed at the site and building plan and the certified survey map? I think it could have been reasonable at that time. The facts are it was not.
Who else has questions?
Well, I have a question for our village attorney. So would there be another avenue that the village could pursue against this pylon sign, which, outside of this particular Chase application, which, would seem to me to state that because the sign became more non-conforming when the new parcel was created, that it essentially lost the protection of 17.48 on non-conforming structures, which says it's a lawful non-conforming structure existing at the time of the adoption. We've kind of created a new non-conforming sign with this new parcel. So could the village, whatever we do when we suddenly there's a new non-conforming situation, issue some kind of notice that it must be resolved, within a certain period of time?
Again, certainly, I think that I think we both agree that a condition could have been put in place at an earlier point.
Right, but I mean, since it didn't, I'm just trying to look for some other way to resolve the situation that we have.
Because we didn't do it at the time of, say, the CSM, which in my mind was probably the more appropriate of the two. Because you're effectively, that's really the action where you created the additional nonconformity, not necessarily the site plan. So I think the CSM was probably the more appropriate time that you would have done it. So I have two kind of thoughts on that. Number one is the direct answer to your question, which is because it wasn't done, if it's not as part of the sign application here, the next real opportunity is the next time there's some discretionary request that's made. We want to change the sign. We're going to change signs on, under the off-premise business sign language. Certainly there, if Fleet Farm wanted to change signs on their own property, we could then make it a condition of something that they wanted to do there. But really, I think because it wasn't put in place, and if you say tonight that you couldn't do it here, the next opportunity is just that next discretionary type situation that applies. Obviously, I mean, you couldn't, under that kind of unconstitutional condition stuff. I mean, we couldn't say, hey, you're putting in a new faucet in the bathroom, and now you got to take down your sign. I mean, you couldn't do that. It would have to relate. So that would really be the answer. And I know I said I had two thoughts, and I don't remember what the other thought was now. So.
For my part, not to give him a second thought, but I would agree with that the village still, if this board grants our appeal and declares the condition invalid, or whatever word you want to use, the village still reserves and has retained a lot of rights. To his point, and to the director's point, it sure seems like signage and a lot of activities going on that site in the last year and in the next year. I'm sure there will be other applications coming forward or other ways. And frankly, I think what I was asked to do initially is to try to work through these things before we even submit an application. But I think those discretionary opportunities, let's not be fools, they're going to be there because that's what the parties are going to want. I just couldn't pull that off before this hearing or before the 30-day deadline. And I wasn't involved before we all marched in when that was going on in August.
And I do remember my other thought, and it's not because of anything he said, it just, he gave me the time, I guess, to do it. My other thought is that in some ways goes to that argument of the arbitrary and capricious, that well, you waited till the last minute and threw it on us. We would get the same argument if we did it as part of the CSM. well, what do you mean you're doing this? We told you we're going to work on it, and why are you holding us up on the CSM? We want to get started with construction. We're going to do it. We hear that constantly from every developer. We amended our standard form development agreement, for example, to, in most cases, provide on a subdivision the ability for the subdivision developer to build a couple spec homes before all of the actual public improvements were done, because they always come and say, well, we got to start. We need to move. It's now. So it doesn't matter when we would have imposed the condition. The argument always would have been, well, you could have let us know before. You could have, for example, to take matters to the extreme case, you heard Mr. Retzloff talk about the fact that they had changed some sign faces, and there was some discussion about the pylon sign at that point. Maybe you make it a condition at that point. Why didn't you do it then? Or the last time you changed the sign, why didn't you make it a requirement? I mean, you can always look back to, well, there was always that last chance that you could have had, but at some point, you get to the point where you just have to impose the condition. And that doesn't in and of itself make it arbitrary or capricious. It doesn't mean that it's the plan commission exercising its will and not its judgment. That question at the end of the day is, what does the code tell you that you're able to look at and consider and think about? Timing doesn't impact that at all, in my opinion.
Question for Mr. Randall, excuse me. Is it fair to say that if your appeal is not upheld, is it really Fleet Farm that is the loser here? At least temporarily, until arrangements can be made for a new appropriate and acceptable sign, acceptable to both Chase Bank and to Fleet Farm, be erected?
I think timing is relevant to answering that question, because the way the condition is written, Chase cannot obtain its four wall signs and 2 directional signs until the pylon sign is gone. And so on a maybe shorter term basis, Chase is stuck and they're not going to open a bank without their signage. And Chase needs Fleet Farm's cooperation, which I would agree with you, they're probably most harmed by losing the sign that they've always had. And again, needing gas prices advertised and what those, because if those change on a daily basis, the public needs to be alerted. So I do think there are multiple parties, and with respect to Chase, then the village is harmed as well, because I don't know that Chase just opens or finds a way. I think this is as seemingly simple of an issue as this is, it's a major issue. And in a way, there's a reason I'm the only one here right now tonight. I don't know that others would have served us any good. Our best track record is showing the dialogue that we were entrenched with village staff. Chase's best record is they're building a multi-million-dollar building and they want to join the community. Fleet Farm's track record is decades of service, and albeit difficult, probably they can come around or they can work on what their signage would be. But the property owner, his track record is like, I'll live with the Fleet Farm sign not being touched, like what Director Retzloff emailed and like what the code seems to suggest, non-conforming. You can't touch that if it stays in place. So again, a long answer, but I don't know that Fleet Farm is the only one that's at risk here. I think all parties have some risk, and it seems, as simple as it is, also a simple solution to me, because I think if the condition is removed, staff can issue the Chase signs, the parties can focus to what's really important, maybe future signage, and if the parties drag their feet or keep hiding the ball, which again I dispute looking at the timeline, then the village just waits for its next discretionary opportunity.
Anyone else? You mentioned that by creating this new parcel, that it makes this currently non-conforming sign further non-conforming. Can you someone explain why it is further non-conforming? Deepens the level of non-conformity?
Sure. From my perspective, you have a code provision that at a minimum says that your off-premise business sign can't be more than 50% of the total sign area. Now, again, that was that discussion of it's kind of inartfully written, and is that the off-premise business sign total area? Is it the total area on that one property? Is it both properties? It's not super clear, but I think the intent was probably of that singular off-premise business sign. The concept is that it's a dual purpose sign, a monument sign, if you will, that has multiple tenants on it. The difference being that instead of multiple tenants on the same parcel, it's two different parcels effectively. And so in this case, you have an off-premise sign that has 100% of its use as the Fleet Farm. And so from that perspective alone, it is non-conforming. And then beyond that, you have the provisions that talk about the Plan Commission's ability as part of that to address the greater impact of signs as a whole, as part of approving that sign. Now, that language does seem to talk more about those signs on the Fleet Farm parcel as opposed to the bank parcel, based on the language that's there. But you've effectively denied the Plan Commission the ability to even consider any of that by just saying, well, here's a new non-conforming off-premise sign that was created in good faith to get us to the point.
Has there been any history of having conditions put on approvals of plans in out of state, like CSM or the plan approvals, where maybe there's instead of you can't start building until you do this, versus you can start building, however, you cannot proceed to the next gate. I don't know what that is, occupancy, who knows what it is, unless you meet the final conditions. Is that ever something that has been done? Any precedents on doing that? Like you can't finish without meeting these items?
Yeah, certainly. I mean, if the immediate thought that comes to mind is every one of our development agreements within the village has provisions that basically say if you don't complete certain public components, we're not going to grant you occupancy. And in fact, there's one developer in particular that we have that fight with them every time they develop something, that they get to the end and what do you mean you're going to hold up our occupancy because we haven't done something that's fairly trivial. So we certainly do. Outside of the development agreement, I'd turn to Mr. Russell. I'm sure that there's examples. I just don't know what they are.
Yeah, I mean, typically even site plan approvals contain conditions that allow them to go forward, but they can't proceed with building permits, for example, until the stormwater management plan is approved by the village engineer or something along those lines.
Yeah, okay, I appreciate that. So if the village was concerned about this sign, then why would they not have done that? Why, instead of waiting until the last moment where now we feel like we got to get it in somewhere because we need to make sure the sign is gone, why would we not have set that up front and say, go ahead and build, start excavating or whatever the case is? You cannot get to the next checkpoint unless you have that, if we were concerned about it at that point. Why would we not put that condition in?
I mean, I certainly can't speak specifically as to what the Plan Commission and or the village board ultimately would have thought of any of those conditions. What I think I can submit, and Mr. Retzloff can jump in and correct me if I'm wrong, but at the end of the day, we chose not to because we do get regular pressure of, you got to be business friendly. You got to make sure that, you're not unnecessarily holding up, the poor mom and pop type business. Not that Chase is a mom and pop type business, but, it's a business that's looking to invest in the community and to, unnecessarily hold them up over something that everybody agreed was going to be worked on and solved and addressed. It just didn't seem to be like an appropriate condition to recommend at the time, because we didn't want to end up exactly where we're at now, where we're fighting over, well, you don't have the right to do that now because you should have did it the last time. It just dragged it out. And where you have a developer and a development team that otherwise does appear appear to be, somebody who's being reasonable, who's working with you, is taking suggestions that you're giving, incorporating it into slightly revised plans. I mean, there's a plan that exists that was very close to something that the village would have approved as a conforming sign that had been proposed, and then at the last minute that gets, oh, nope. We decided we don't do that. We don't know what the issue was. Not enough space to farm and fleet, or fleet farm. Sorry, I'm a Waukesha guy, so it's always farm and fleet to me. But we don't know why that proposal that otherwise seemed to be compliant got pulled off the table. And it's not necessarily relevant for this evening, but we routinely do those circumstances. There's countless projects that Attorney Randall and I have worked at, both here in Germantown and other communities that we represent, that it's that same process. You have that good relationship. You're not going to, throw the monkey wrench in just over something that everybody's already committed to working on. So you just kind of keep plugging along because you know that you're ultimately going to get it resolved. The challenge here is just that for whatever reason, the parties on that side were not able to come together and say, okay, this is ultimately what we're able to live with, whether it's, something that was fully compliant or something that was at least reasonably compliant that just needed to get a variance for, height or, something, that we don't know exactly what happened on that end. But, again, at some point you just got to say, okay, I mean, we're happy, but, and I think leverage is the inappropriate term to use. And it's unfortunate that that's reflected, in the Planning Commission's thought. But that's not the intent here. The intent here is just to reflect what we've always known all along since the beginning, which is you got to take care of the sign.
If I may briefly respond to that, which is, I think that's the key question. Why wait until the last moment? And again, I hear the village representing its case as they didn't want to upset the apple cart at the very beginning. They want to be pro-business. Sounds to me like they looked the other way is what they're saying. When I've conceded that probably was the appropriate time. And if we all can just make up what history would have been, I would submit to you that I think in November, a year ago, that would have caught the party's attention. And maybe they wouldn't have waited until January to send Jeff the first email, hey, we want to get this going, May to have elevated identity, start drawing fleet farm signs, et cetera, et cetera. Maybe that would have been when the leverage was best exercised because that was the appropriate, reasonable time for the condition could have been. So I think the timing is what's key. And the word leverage is what's key, that the village did wait until, and Brian's been saying it too, the last chance that they had. Well, again, these sign applications were for a package of Chase Bank, 4 wall signs, 2 directionals that no one has a problem with, that everyone's excited about Chase. And to conclude with Exhibit G, page 2, the director's email, August 19th, after the condition was passed, quote, if Fleet Farm wants to keep the pylon sign, they can continue to use it as is, but cannot make any modifications. That's the legal non-conforming law. That's the reality that the village said would just have to be the life we would all live. And that's why we're asking for the appeal, because at this point, we're stuck. Without Chase getting the wall signs, they're not going to open. Without, Fleet Farm's agreement and more time to get their agreement, we can't take that down. And so that's, I think, the key point here is that last moment is what caused the hardship, what really was unreasonable, what was arbitrary in the context of that application, even though I think an earlier point in time, it may have been reasonable and it wouldn't have been arbitrary.
Can I address the question?
One more concluding thought. During the course of our timeline, we never said we were going to stop working on the plan. Again, the Chase application came in on June 10th, but Mike Kinsella in the emails in June 17th, Jeff was asking for clarification. What's up? I'm getting these dueling things. Westfall, Jana from Langberg Electric says the staff will be asking, is the staff going to be scheduled for review, provides the right plans. June 26th, Mike Kinsella clarifying with Jeff the other day is what he told our team. So they must have talked. June 27th, There's an email replying to Jeff, clarifying the packages, apologizing for the confusion, indicating that a variance application was going to be prepared to respond to the 6-5 staff memo for the Fleet Farm new sign package. Again, we're working on it. Good faith, some diligence, maybe it takes long, but deals take a long time. But Chase had to submit the uncontroversial signs June 10th just to get that moving. And they originally said pylon not to be altered. So this is where I point to you, our good faith, but at some point, the faith just stopped because the village took the leverage position, the plan commission adopted the condition, and then I couldn't mop up after the fact, even though I was trying to work it out with staff. I believe we will continue to work it out, but the condition is what's got us all stuck. Sorry, I know you wanted to respond. I just wanted to complete that thought because the record does not state we told the village to go fly a kite or that we're hiding the ball or they can't get their shiny object. It just took a long time. I understand and I recognize that.
To respond to your question, I was the one who wrote the staff report to the Plan Commission and the recommendation that they ultimately followed by approving the site plan without any specific condition dealing with the pylon sign. The term good faith has been kicked around tonight, and in large measure, it comes down to some of that. You know, like going to the grocery store, I'm 65. I don't expect to be carded to be proved that I'm of age. So when Jana Westfall from Lemberg Electric presents herself as I'm on the job now working for Fleet Farm and Chase Bank, and I'm telling you that the two are working on a new design within code, implying that they're going to come up with a design that addresses the pylon sign and that's going to be a code compliant solution. Okay, that was on November 7th. November 9th, Taryn Wright, the person who's signed the site plan application, also responds in an email in response to my concern again about the pylon sign. What are we doing about the pylon sign? Well, that's been resolved or being resolved. The signage vendor is working on the signage package now. Chase and Fleet Farm are working on a new multi-tenant shared sign where the existing sign is located, more to come. So it's this, okay, you're working on it. I don't see the reason to build in a hard and fast, you've got to take this pylon sign down, now let's proceed accordingly. And it wasn't until March when Taryn Wright from the architect group, wants to know, what's holding up our permit application? What's unresolved? And I bring to the attention the pylon sign status. What's going on with that? Not that was holding up the permit, but it was one of the issues that was still unresolved. And the answer is that they're working on a sign package. And here it is. And he sends along with an email a copy of the sign package that shows monument signs or a monument sign that would replace the pylon sign in the same location that, for all intents and purposes, is code compliant. So there's this thought that we're moving forward and we're not having to, bring our attorneys to the table each time we have a conversation and communicate about progress.
The other thing that I just wanted to just briefly comment on, because he kind of raised it during some of the questioning here, is this concept that, well, all we gave you was, 6 individual sign applications. There's a directional sign, a couple wall signs. The code, I think, pretty clearly talks about the appearance, location, height, all of that kind of stuff. It is not a sign application. I mean, unless it's truly just a sign that's being proposed, I'm going to replace, Sundix is going to replace their wall sign street. And it's one sign and that's all they're dealing with. You're going to look at that. But when you have a new property like this that has a slew of signs that are being presented, you consider those as the full package. And one of the things that you're doing when you're looking at that full package under the code, in terms of appearance, location, how well it identifies the individual proprietor, the language within the code, that kind of stuff. All of those signs are considered, kind of as a complete package. Yes, it's an individual application because that's what ultimately the code says, is that each sign needs an application. But where you have a development like this, that package is considered as a whole of, we're going to modify this sign in exchange for some change on this sign, that kind of stuff. And that's really, at the end of the day, where you then start looping in the concept of, well, there's this other sign that we got to deal with that's on the property. Just like when we would look at that Sendix sign, it's just that one sign, but certainly one of the considerations that you're going to do as you're doing that is how does it fit within the building as a whole? Are there issues? Is it too close to another sign that's going to create some confusion? Is it, there's all of those factors go in even when it's an individual sign, but let's make no mistake. This was an application for the full slew of signs for the site, and the site includes that pylon sign.
I just want to briefly respond at the end. I don't know how one can make that argument when the applications are specific to the signs, as I indicated, and there were active discussions. I'll agree that, yes, there were discussions about that other sign and the overall site, but I don't think it just automatically expands the scope of what's before. Now, the village could have deemed these incomplete or demanded, there's another opportunity the village could have had, kick the Chase sign application back, or I think one of the board members asked, deny it outright. The time was at the time of site and building plan, or, and I guess I'm starting to agree with Brian, certified survey map approval. And I'm going to be very careful because I will work with village staff in the future, and I like working with them. But I do have to just respond to what the director said a minute ago about it wasn't the right time and they didn't want to put that condition about signage in November of 2023. In Exhibit A, page 6, is the village staff recommendation. And here are just 4 of them that I think were important enough to the village to put in at that time, and this signage one wasn't. Number 4, all technical issues and plan corrections identified by the village engineer and public works staff, see a memo, shall be addressed and reflected in the revised plans. Number 6, the existing 6-foot wire woven cyclone fence, those are ugly, installed between the Cornerstone Center and the Chase Bank parcels will no longer serve its original intended purpose and shall be removed prior to the issuance of an occupancy for the Chase Bank. There are some things in here that are important and they want taken care of, and they're not shy about saying, so maybe number 10 should be the pylon. Number 7, traffic circulation measures. A, put a do not driveway sign, install a single inbound lane. B, install minor leg stop, et cetera, et cetera. And number 9, the west building elevation is a little plain. It's monotonous, do some stuff to it. So the village does have a track record of putting important stuff in there. And if I have to concede that a reasonable time to have done the sign condition removal would have been this time, then it should have been number 10 on that list. And so again, I respectfully I want to be careful because I will work with these guys again. And I'm not trying to make my next approval recommendation 22 points long with conditions. That's what Wauwatosa did to me at one point. But that's the reality. I think that was the time. And then just finally, yes, Taryn Wright, Jana, all these people, what was authorized to be applied for, what was submitted, and those dates that Jeff talked about, November, March of 24, those still predated then when Mike Kinsella sat in their office and met with them at least 2 or 3 times in May or June, asked for the variance application, knowing, of course, another discretionary decision, no guarantees, but we know there's a process. So our team at all times was trying to do the right thing. We know it was frustrating. We know there were 5 different sign companies, but at the end of the day, the village's authority and jurisdiction is invoked when an application comes in that's signed, fees are paid, and sometimes the phone rings and those people don't have authority to say what they're saying or to email what they're emailing. And maybe that's at best or worst, depending on how you look at what happened here. But the focus on the condition, when it was imposed and under what authority with the ordinances, is what I'm trying to reframe the board back to just make sure. This has been a fascinating discussion. Frankly, the legal nonconforming, if it made it more legal nonconforming, I think is a really interesting question. To me, interesting questions in the law make for good appeal issues. And I don't know that the board needs to go there. Maybe we would all agree it made it more non-conforming, but I don't think I agree with that. I think there's authority there because one could say, okay, well, if the plan commission caught that, then maybe the applicant would have said, all right, well, I want a variance and I can address those code things, and maybe the pylon sign or a different one can still be an off-premise monument sign, multi-tenant, et cetera, et cetera. So there's always process that could be invoked, but it wasn't invoked in this case. And I think it just simply boils down to, was the leverage and the authority exercised when it was too much, and will the village have its chance another day? The answer to the first one and the second one is yes. It's kind of giving you my closing argument, I guess, to not cut off any questions, but I've literally crossed off things that the good village attorney raised, good points the staff made, and I know they got a lot of emails on this, because like I said, yesterday was probably the first time I had crystal clear, and I put this darn timeline together, like, who said what and when and who were they? Confusing, frustrating. Tonight we can end all that and take a big step forward.
I've got one more, and I think we're kind of past this, but it came to me a while ago, and I'd still be interested in an answer. And I may be 100% just off base, but I'd like an explanation. Can you take a look at Exhibit E in the packet, and then turn to page 5, which is the Sign Tech drawing that shows the Fleet Farm and Chase monument sign.
Yes,
You see that?
yes,
In the upper right-hand corner, it says existing monument not to scale, and that's the one we're talking about being required to remove, right?
yes.
And underneath that, it says monuments to be removed by others. What does that mean?
So that, I believe, is what Taryn sent to Jeff in March. Or I definitely believe, and I'm told via my timeline, that's what PAP, and again, that's where Taryn is, in the context of getting the building permit, staff was saying, hey, what does the signage look like? And so, I'm sorry, here's my timeline. So yeah, on April 14th is when my team told me, that's why I highlighted it. And that's why in the timeline, this sign plan has red. The R11 sign, which was revised on March 8th, I believe, I first believe April 15th is when staff first saw that, but maybe Taryn sent it to Jeff, and I've never talked to Taryn, and Jeff may have an email on that. The key to that, so then what is Exhibit E, if you look at page 2, the Chase cover, it's hard to read on the bottom, but there's on the bottom right, if you turn it, R11, March 8, 2024. And page 2 is also important. That's a page that shows like a splash page of where all the signs are. I think on your copy, I've highlighted them. Yeah, sure. Look, first 2 lines, G1 and G2.
Yep.
Those are ground signs, double faced, 10 panels, 50 square feet. I believe Jeff was alluding to, those are probably code compliant. Flip to your page 5. To answer your question, first part of it is I didn't highlight it, but the blue box shows G01. So remember that site location. Okay, the G01, where is that on the site? They're telling you existing monuments to be removed by others. It's clunky sign phrase, but that means someone else is going to take that pylon down and put a 8-foot 2-tenant panel monument sign.
Yeah.
So this sign plan existed. And we had it internally, and the village was sent it. But the other key part of Exhibit E is what I highlighted on the very first page, which is Jeff's June 4th email to Mike Kinsella. Mike is the Fleet Farm sign guy, probably the last Fleet Farm sign guy involved, had met with staff at the end of May 30, 31, couple times. And Jeff, to his credit, seeking clarification. Mike, can you please confirm that the attached sign package proposal has been withdrawn and should no longer be considered by the village? The attached sign package was the R11 with an 8-foot monument. Give me a minute. That one didn't have Mike's response, but Mike's response would have been on June 4th. Exhibit D, page 4. Again, I got email dumps here, but Exhibit D, page 4, actually, if you look at page 5, there's Jeff's email again from June 4th. Mike, please confirm that the attached sign package proposal has been withdrawn and should no longer be considered by the village.
Yep.
Bottom of page 4, confirm the attached package should no longer be considered by the village. So before Chase applied, while Mike was still trying to work magic with the parties, what's going to work for Fleet Farm, what's going to work for everyone, trying to provide some clarification. Yeah, throw the R11 one away. It has 8-foot monuments. We know it probably complies, but we can't apply for that. We can't say that's our sign plan yet. And I know village staff had it, and I know they would probably say, rubber stamp, it's approved. It complies. But we didn't get there yet. And we may never get to that one. We may have a different version. So apologies, everything for this is a long story, but that's the key. Yes, those plans existed. Yes, they showed a code compliant sign likely, but we tried to clarify that that's not what the
I
party.
get all that. My question's far more trivial than that. It's just that the village did have something where a representative of Sign Tech said the monuments to be removed. They did have that, right? As of the
April-
date that this email was sent.
Yeah, the representative.
That's why I say
was-
we probably are
Correct.
past this. It would have been a question that I would have asked earlier, but I only caught it, you know.
It does come back full circle. Like, everyone's right, Brian's right. The owner has to sign one of the village applications. I mean, all this was done for good reason. The village got burned at some point where someone's like, I didn't authorize that. So owner and applicant always have to sign. TAP was Chase's architect. That's where the May 15th thing, the Terran guy was communicating with Jeff. So if I'm Jeff, sure, this person is authorized. But what I'm here to tell you is, well, they're authorized by Chase. Chase is paying them. Fleet Farm isn't paying them. My client, the landlord's not paying them. And whatever they're doing still has to be okayed by Chase and landlord. The one time that Chase and landlord did agree, and Fleet Farm, is when we submitted without dealing with that pylon as of yet. So TAP's authorized by Chase. It kind of comes back to the beginning. Yeah, we are full circle. It's important to know who it all is, and we could have done a better job. But TAP was not authorized to submit the sign package for a permit. They didn't. They sent it as a courtesy, and maybe that was the one misstep that messed it all up. But TAP was authorized by Chase, but they weren't working for landlord or for Fleet Farm.
All right. Anybody else have any questions? Everybody good? Yeah. All right.
If I may just, you kind of had a brief.
Oh,
summary,
yeah, go ahead.
If I could just very quickly, I'm going to go back again, full circle. We're going to go back to the beginning. All of these emails and discussions, between staff and the various folks are interesting. And when you take them and you try to take all of those discussions and you apply it to the Plan Commission's action, you're arbitrary. That's the argument, right? That you chose the last minute to do this and you're looking to just punish us because of this. Remember that the Plan Commission wasn't purview to any of those things. Plan Commission knows that in the site plan application, that's Exhibit A, staff report talks about the fact that applicant has indicated to Chase and Farm Fleet are looking at a new code compliance sign and that we're going to get it back. Have a separate application for that. We get an application and appears to be the last application as that relates to this particular development. And it imposes a condition. Nobody has disagreed with the concept that Plan Commission could have just said, nope, we're not going to approve any of these signs. One of the reasons that they can do that is the code talks about the fact that you look at all of the various factors that the intent talks about, location, height, other signs in the area, all of that kind of stuff is part of their determination. If they can say at the end of the day, nope, we just don't approve it. They can say, well, we'll approve it, but we're going to put a condition on it. Nothing wrong with them putting a condition on it. And to impose some level of malice on the part of the Plan Commission based on all of those discussions that took place between staff and the various applicants, and staff is frustrated and they're looking to punish it, just isn't fair. It isn't true. You have to look at the decision that the Plan Commission made and whether or not they acted within the law. And as soon as you admit that you can just flat out say, we're not going to approve this, you can say, we're not going to approve, or we're going to approve this, but we're going to impose a condition. Just like they could have, leaving the pylon sign out of it, they could have said, we're going to approve your package of signs, but we're going to impose a condition that's going to say you're going to need to shorten up one of the wall signs as a condition. We don't need to see it back, but we're going to impose a condition that says you've got a 50 square foot sign. We're going to make you move it back to 45 square feet or whatever. We impose conditions like that all the time. And as soon as you admit that you can impose those conditions based on package as a whole, the site as a whole, the location of the property and the community as a whole, this is an appropriate condition to add.
As the appellant, I have a very brief response.
Go ahead,
if I
please.
may. First thing, I forgot to make this record, though. I have no objection to the village attorney sitting and representing as he has done, but I want to make clear the record, and I think he'll agree or confirm this for you. Unlike the item number 1, the variance, he is not appearing before you to advise the board. He has been advising or working with the village staff. And I just want to make sure the record is clear on that, unless he's going to catapult over and start whispering in your ears.
No, in fact, I would, notwithstanding the board's apparent thought that maybe I was representing the board in the last hearing, I was actually here on staff's behalf to address the issues that we anticipated related to the disability stuff. So I am here this evening as the staff's attorney, not the board's, and would agree with that.
So strike my comment about whatever he was doing for agenda item number 1. He's representing staff, and if you feel like you need legal counsel, you probably have to, do a recess and reconvene, but hopefully not. You've heard enough from lawyers tonight. So briefly to conclude on what village attorney just said, here's where I disagree, which is what he said. If one, maybe I agree to this at some point, if the plan commission could have flat out denied the sign package in August of this year, I think the translation of what he said is then they can add conditions, like that one thing leads to the next. And I disagree with that because the plan commission cannot, without basis, willy-nilly, a non-legal term, and just deny things that otherwise meet the code. And so it all ties back to the code. And I agree, the plan commission could have denied the package that was filed back in August of this year. But I think we would have had an appeal to this board or a quicker trip to circuit court because what's wrong with the package that was filed? So I think it's mincing words, just say they could have denied it, and that somehow equates to justifying an unreasonable, invalid, arbitrary condition as I've labeled it and he's labeled it as reasonable. So I think you're going to want to focus your discussion on that. And then the final thing just related to that, and it comes back to the timing though, irrespective of the plan commission not having all these emails, the minutes, Exhibit F, from August 12 of 2024, the Plan Commission did hear from Tina Lewis, Representative Lengberg for Chase, quote, asking if the Plan Commission would consider allowing Chase Bank to move forward with their sign installation if the replacement of the Fleet Farm pylon sign is not ready. Consistent with what I said, we never said go fly a kite. We're not ever going to do it. It wasn't ready. She was there, olive branch. Can we just hang the Chase signs? These are minutes. I don't know what else she said or how she phrased it. But the key here is that's the meeting where the village chose its timing point, used leverage, which I argue is what makes it unreasonable, arbitrary, and invalid in the context of this holistic process. And unfortunately, this process unfolded the way it did. We're all stuck here with it. I've tried my best to just advocate and look at what it is. And I know these are hardworking people, and it would be nice if every application was four corners with a nice tidy bow and otherwise compliant, but they've probably seen worse than this. So the key is the timing and the action behind it. And I think the Plan Commission knew exactly what it was doing. It was exercising its will. It was using the leverage they were being implored to do because it was the last minute and they knew it would get everyone's attention. And unfortunately, though, it might also create a hardship where there's a big problem over on that corner. Thank you.
Well, because we don't have a lawyer, I have no idea what to do. The last time we had one of these, we went into closed session and we deliberated ourselves. But at that point, while Mr. Sadak represented the board and represented the village had hired us our own lawyer. that I could ask this question of? I literally don't know. Do you know?
Yeah.
What was the question?
The question is, what do we do? Do we deliberate publicly, or do we go into closed session and deliberate like we did the last time with that, with the one for the apartments?
But the agenda is agendized as such that there is not the closed session portion.
Oh, so we can't do that?
You typically
could
do it
not
in open.
That this evening,
Okay.
because it's not agended for that purpose.
I
Now,
see.
you could certainly, and you heard Attorney Randall talk about it a moment ago, you could certainly adjourn, schedule another meeting. We can get an attorney to come in and sit with you, and he can pester him with all the questions that you have. Certainly not a problem. We can do that in terms of doing that. The one nit that I might have is just, while that attorney at that time suggested that going into closed session was an appropriate thing and perfectly okay, I didn't agree with that. And so,
Okay. Well, we issued a written decision in that one too. I'm not anticipating that in this case.
Right. That one was a far more complex circumstance than this, I think, at least in my opinion, but, certainly if the board, thinks that you would be assisted by legal counsel other than hearing from two other lawyers yelling back and forth at each other, certainly that is an option that you have, that you can adjourn and we could get somebody on board.
Well, let's talk about that very.
But honestly, just so you know, the reason that we didn't is the one that I had kind of pegged for it, called kind of at the last minute and said, I can't make it. And my fallback is his partner. So. Didn't think that would work.
I would just add, I would love to have a decision tonight, but again, as I started tonight, I was on the Board of Zoning Appeals in Tosa. I know these can be tough. You may want to distill your thoughts. So the lawyer in me, he's more of a lawyer. He quoted case law to you tonight, and oh boy, if we're talking case law, I didn't at least do that, especially for the non-lawyers. But I will quote the ordinance, and I will remind you, since you don't do it very often, 17.52 sub 7 on a decision says the board shall decide all appeals and applications within 30 days after the final hearing and shall transmit a signed copy of the board's decision. So I think you have a window if you choose to exercise it.
I see.
And this may not even be the final hearing, but to give you that as a helpful reference, you could take time. As much as I would like to say, I think I gave you a real clear-cut case. Why don't you just make the verbal decision and write it up later? But I understand that you may want time, and I think you'd have the authority to do that.
What's everybody think? You want to do our deliberation now? Well, and as Brian says, he wasn't necessarily in favor of the closed session anyway. What do you guys feel like? You want to, we can adjourn for, well, not a week because that's Thanksgiving, but we could come back in 2 weeks and deliberate then. I don't know that it gets any fresher. I don't know that that's preferable, but.
That unless we are going to deliberate with something different or something else, if we're not doing that, then I don't.
Yeah.
But all that's going to happen is we're going to forget more of it.
The legal decision that we would ask an attorney to clarify for us is whether the splitting of the parcel from one parcel into two, as I understand it, then authorizes the planning commission to make changes, forced changes to the pylon sign. Is that the legal question that really is outstanding at this time?
Well, I don't know. But I do think that we wouldn't ask our lawyer for the legal answer. That's what we're supposed to decide. And so we have to figure out from the arguments of counsel what the legal question is, and to me, it's just a question of, not just a question, but it's a question of, does the Plan Commission have the authority under the code to impose the condition that it imposed on granting the sign permit? And so one of the arguments was that because this was an off-premises sign, that made it extra non-conforming, and that was a justification, but that was just one argument. But no, I would think, just me anyway, we could ask the lawyer this. I would think we wouldn't ask the lawyer, what's the right legal answer, because that's what we're supposed to decide. So I don't know if we get any benefit from that or not. I just remember the last time we just did it in closed session and he was able to tell us he didn't tell us what to decide, but he told us how to do it procedurally.
I'm failing to see how that would assist us as well.
Yeah, I'm kind of
And
thinking.
if that's the case, I think that we deliberate tonight and make a decision. And if the party that fails in their endeavor seeks an appeal beyond
Yep.
this board, then so be it.
Okay. You agree? Okay. All right. Well, then what do y'all think? So anyway, I'll declare the hearing closed and we'll begin our deliberation.
If I could, Chair.
Yep.
I noticed that on the portion that we had the 5 questions related to the variance.
Yeah,
As it relates to this,
we just
we
answered.
just have the appeal, the conclusion of the law.
Yep. Yeah, so our only conclusion is whether the condition imposed by the Planning Commission is or is not in excess of its authority and why. Who wants to go first?
I'm sorry, in this 4-page document.
Mhm.
In this 4-page document, where are you finding that exactly?
And it's the first one under conclusion of law on page 2.
Okay, thank you.
Anyone have any thoughts? I'm willing to be persuaded, but I'll tell you where I am right now. I think that the Plan Commission does have authority to regulate, what it does when it approves signs. I think that without regard to that architectural control section, which I think could have maybe, I don't know if it has anything to do with it, but I think even just under the sign statute, it's the Plan Commission's role to look at, how this is all, how the whole, how the sign how the sign is gonna look. And I think that's part of the consideration. I think that as a result, that since this was being talked about, now whether the Plan Commission knew that or not, it certainly was part of the recommendation from the original site plan. Although it wasn't a condition, there was certainly contemplation that the non-conforming sign would be removed. I would think that given the type of discretion that the code gives to the Plan Commission, it's my preliminary conclusion, and I'm interested, and I could be talked out of it with a compelling argument. But my initial conclusion is that that Plan Commission had authority to impose this condition. I also think that I'm a little persuaded by Brian Sadek's argument that if it could have denied the whole thing outright, and I understand that Mr. Randall's argument is, well, it couldn't deny it outright unless it had a good reason. But if it could deny it outright, it seems to me you could almost say, well, look, if all right, this is the condition. If it could have denied it outright, you say, well, here's the condition. If you don't fulfill the condition, just consider it denied, which we could have done. See, this is why I didn't want to go first.
I, I find that the village, in my opinion, was not capricious and arbitrary in their decision. I recognize the fact that the planning commission is the umbrella decision maker in these matters. But Mr. Retzloff and Mr. Yankee are the workers that get the work done. They get the tasks done so that the planning commission can make their decisions. And in doing so, they have to work cooperatively with, in this case, two businesses, a landowner, and as Mr. Retzloff testified, as many as maybe 5 different sign company representatives. That's a lot of personalities, a lot of phone calls, a lot of emails. And there are certain allowances that are made, I'm sure, in order to allow all of those parties to cooperate, to get together, to communicate, to come up with a plan. And it's incumbent of the sign representatives to communicate back to the people that they represent the urgency of taking care of the pylon sign. And it seems that's where the downfall was in my mind on that side of this issue. Now, that's not to say that perhaps the village couldn't have communicated a bit better, a bit sooner, a bit more directly, and maybe this hearing could have been avoided. But sometimes these things happen in complex matters such as this. That's all my way of saying that again, I don't believe that the plan commission acted in an arbitrary or a capricious manner, and that they do have the authority based on the changing of the parcels, the dividing of the parcels that gave the plan commission authority to regulate and force a change to the pylon sign.
So I guess, I agree that the Plan Commission does have the authority, of course, to regulate signs and, issue their approvals or not approve things, as they, interpret the code. I was, somewhat sympathetic to how frustrating the lack of progress on the pylon sign has been, for the Plan Commission, village staff, and, I can see that, there's been a lot of time and effort, spent trying to get progress there. It's very frustrating. I wouldn't go so far as to call it anyone operating with a lack of good faith or, anything like that. It's just kind of the way things go when you're trying to move the ball down the field. It never goes as quickly as you'd want it to. So I understand the frustration, but, I'm also sympathetic to it seeming to be suddenly something thrown on at the 11th hour, now that is causing a difficulty to a business that we do want to welcome into Germantown and, have be part of our community. So, clearly there's authority, whether it's reasonable to throw that condition on at this point when it could be done earlier, I guess is, what I struggle with.
But you ultimately come down on that balance that it probably,
I think it is within,
Yeah.
their authority.
Have any thoughts?
I do. I'm formulating.
Okay, oh, good.
The troubling part is, so I think that I probably have to agree that they probably have the authority to do so. The troubling part for me is that this feeling of using goodwill as a crutch for poor risk management, right? I think it was just, to me, that's like the burning part here. And, for those that don't know me, I've been in project management my entire career. And so this screams terrible risk management. And so that's I have to get past that because, I think in the end, I think they probably did have the authority, but exercised it poorly is my opinion. Yeah.
Well, we've got to answer the question. The order of the plan commission, sounds like we all say, is not in excess of their authority because, and let me tell you what I scratched out and see if we want to use this as the because. Not in excess of its authority because the plan commission has some discretion under 17.46, and the decision was not arbitrary or capricious because the non-conforming sign was always an issue, and it was incumbent on the sign representatives to inform their clients of the issue, particularly that given dividing property rendered the sign an off-premises business sign, and Plan Commission had authority to require removal as part of the site plan or CSM approval. I tried to I didn't say poor risk management, but but I tried to incorporate something everybody said, but I did.
I would agree with your summary.
Yeah, I think
Good with that.
I think it's a good summary.
All right, and I can write that out for you or give it to you or you
You
can.
would write it out for me and email it?
Okay, sure.
Then
All right, so based on that summary, then I think, I don't know I don't know if it's a motion. I don't know what we do. I guess we, I don't think, it doesn't feel like a motion let's just vote on the appeal. The question we'll call is, did the plan commission exceed its authority in imposing the condition?
Mr. Chair.
Oh, yeah, please.
And I'm going to ask Attorney Randall to jump in here, just because, again, I'm not your counsel, and so I want to make sure that
Well, if the
we're in
parties- if the
agreement.
parties stipulate.
I trust him to start talking.
We will,
and
yeah,
I'll-
we'll.
Right, he's going to smack me when I go
Stipulation.
right. I think you need to make a motion.
Is it a motion? Okay.
And I think that the motion at the end of the day is just whether, to either approve or to deny the appeal. And that
Right,
motion
that
is
makes sense.
based on
That
the
makes-
findings
Yeah.
that you made,
All right,
that you just read.
all right.
Fair?
Yes.
You counseled me on that at the board review about whether we need a motion or not.
Yeah, no, yeah, that makes sense. All right. Can we phrase the motion in terms of the negative to deny the appeal? You can do that, right? Okay. All right, then I will.
But I mean, if you want to be like the ultra Robert's rules now.
Yeah.
No. But
Okay.
I've always said that Robert's rule sucks and you should just go.
Yeah, we're not going to do that because if we phrase it in the positive, the motion is to grant the appeal, then it won't get seconded and there's no good way to put the because in. So we're going to do the negative. I will make the motion that we deny the appeal for the reason that I read, which I will email to our, in fact, I can do it right now. to our esteemed clerk.
I will second it.
All right, the motion having been made and seconded, Madam Clerk, if you would call the vote.
Board Member Edwards? Board Members Knapp? Sorry, nay?
Nay.
Board Member Huber?
Aye.
Can I ask a question, please? I just want to make sure I understand that the motion.
The
that
motion is
Mr.
to,
was correct.
the motion is to deny the appeal.
Thank you.
And so a yes vote is against Mr. Randall, saying that a yes vote is that the Plan Commission had authority.
Thank you. I apologize. Can I change my vote?
Do I have to do an amendment? Okay, I'm going to, just for the record, start roll call over, just because of clarification, clarification as to the vote and how that is determined. Starting with Board Member Timothy Edwards. Note for the record that that is aye. Board Member Knapp,
Aye.
Board Member Huber,
Aye.
and then Chairman White.
Aye.
And for the record, that was 4 ayes.
All right, gentlemen, thank you very much. Do we have another hearing scheduled? Or anything else on that's coming up?
There are no future meeting dates at this time, no applications in-house.
All right. If someone would be kind enough for a motion to adjourn.
I'll make a motion to adjourn.
I don't think it requires a second. All in favor? Aye. We are adjourned.
9:06 p.m. Thank you. And
I'm typing it right now.
I don't, but love that.
Here, you can have mine.